Please, your lordship. My lord, there is a notice that, my lord, the matters before court number 21 will be deferred and urgent matters we, my lord, mentioned before your lordship.
Item number?
My lord, item number 2, in fact, my lord, I am not mentioning because there is urgency. Mentioning because, my lord, the briefing council comes from Delhi. Therefore, a fixed date may be fixed, my lord, after holidays, my lord. I have talked to
Item number 2.
item number 2.
When
Sometime
do
in
you
the
want?
first, sometime in the first week of May, my lord. First week of May.
Ultimately, it will be second week. The first week only 2 days.
He'll be for the other side.
On 6 or 8.
8. It will come for admission on 8th.
On the fair being made by Mr. Item number 2.
Item number 2, man.
8,
Learned senior counsel. Consent.
What day?
This is a list the matter on 8.
I am appealing for the respondent.
Okay.
May I please lordship? I was beg to mention the item listed before the court number 21, my lord. So item number 4 listed for hearing, my lord. So it may be, my humble prayer may be fixed in a date, my lord. On 29th April, there are 3 more cases, the identical cases. So it may be fixed on 29th April.
On the fair being made by Ms.
Item number 4 of the
M.
court number 21.
M. Settlesey, learned standing counsel for the Daniel Railways. You inform the other side
Yes, my lord.
with consent from the other side. First for listing the matter on
29th.
29. Okay.
Bless your lordship.
May I please, lordship? May I please, lordship? I get to mention my lord unlisted matter for list.
Yes, Mr. Singh.
Item number 8, lordship. I'm on behalf of S. Ahmed, lordship. He's
Item
not
number 8 of this court. This court.
this court, lordship. He's not well, lordship. He could not come. I mean, possible for the day, lordship.
On the prayer being made by Mr. Sharma, learned counsel appearing on behalf of Mr.
S. Ahmed.
S. Ahmed. Learned counsel for the petitioner, SSL is the matter on
Any date, lordship.
after vacation.
I'm for the respondent list.
Item number 8.
8. Oh.
Any objection?
No.
No. Okay. When do you want?
Any date, lordship. Any date.
Okay.
Please. 30 April. Oblige, lordship.
Yes.
My lord, I get to mention an unlisted matter for listing
When?
on 9, my lord, 9/4.
9th of April.
Yes.
Wait, please, your lordship. Lordship, I beg to mention for listing one admission matter of 2023, my lord. May I pray on, my lord, 8 or 10?
What matter?
In test petition, my lord.
What? When do you want?
8, my lord.
8.
On
8 is
10th,
hearing.
10.
10th.
And
May it please your lordship. Lordship, I beg to mention item number 7 listed before court number 21, lordship. The date may be fixed, lordship, on 22nd of April,
Item number 7.
lordship. 22nd of April, lordship.
You inform the other side.
Lordship, I informed.
Mr. Your good name.
A.K. Kanu on behalf of M. Ahmed.
Learned counsel appearing on behalf of Mr.
M. Ahmed.
M. Ahmed, learned counsel for the respondent with consent from the other side. First for listening the matter on
22nd April, lordship. Oblige.
Please, your lordship, I beg to mention for listing a mate appeal
when?
on 10 for 10
After
April.
Bihu, lordship, so many cases. After Bihu,
Lordship.
on 21st, first day.
On lordship, court number, item number 6 also may be adjourned for today.
Item number 6
6,
of which court?
21,
21.
lordship.
Item number 6.
6,
On the prayer being made by Miss, your good name, please.
A. Burman.
A. Bora, learned counsel.
Burman.
Ellen.
For the appellant. Item number 6, I appeal for the appellant.
Ellen. You are for the respondent. Learned counsel for the respondent number
1,
with consent from the other side for listening the matter. When?
after Bihu.
After the vacation. Okay, rest they will fix that. Yes.
May I please, your lordship, I beg to mention for listing of one RSA and one CRP matter, lordship.
When?
After Bihu vacation,
After
lordship.
take it from him.
One on 25th, one on 28th.
Yes.
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 17, lordship.
item number 17 of this court.
Of this court. I've taken the concern, I'm for the appellant, Lordship. After vacation, Lordship, we proceed.
Mr. S.P. Sharma, learned counsel with consent, other side. Is for listing the matter after.
Before vacation, fixing a date, Lordship.
Before vacation, after on 1st May.
Lordship, my name may be recorded for the respondents, Lordship. Item number 17.
You are for the respondent.
All the respondents.
Your name is already there
Yes, Lordship. Lordship, my name may be recorded
today.
for today, Lordship.
Why?
Lordship. Lordship. With our consent, Lordship,
Pardon?
my presence may be just recorded.
Okay, I have already recorded with consent from the other side.
Lordship.
Okay. Mr. P. Solia, learned counsel for the respondent number 3 and 4.
May please, your
Yes.
lordship. Lordship, I beg to mention for listing a matter, CRP matter for tomorrow, your lordship. CRPI, your
In
lordship.
whose column?
Motion, your lordship, for motion.
1 minute.
May I please, Lordship? I pray for listing of the MSC before going after the vacation, Lordship.
Take a date from.
May I please, your lordship, I beg to mention for listing lordship. RSA matter, lordship.
When?
Any date, lordship, after Bihu.
In whose column?
Admission, lordship.
After Bihu,
After P. Take a date from.
25th April.
Yes.
May it please the lordship, I beg to mention for listing of this MSC appeal for orders tomorrow, lordship. Because this matter has not been listed since last 4 years.
On 7th, Monday.
So,
Tomorrow,
Tomorrow.
we have got 40+ cases also.
Lordship,
Lordship, I
beg to mention listing of IA civil in connection with MSC appeal.
When?
Lordship, 9th of April.
Please, your Lordship, I pray for listing an RFA matter on, for orders on 7th.
7.
7th.
Of April.
Okay.
Are similar prayer.
May I please, Lordship?
Yes.
Lordship, I pray for listing of RSA method for admission on 8th.
After Bihu, sorry, after
Can it be
Bihu,
on 11th?
too many cases already. After Bihu on 21st,
vacation.
just opening, just after opening.
Yes.
May I please, Your Lordship? I pray for listing and make appeal for orders, Your Lordship.
When?
Any date after Bihu 21 or 22.
23rd,
I'm so obliged.
Take a date.
Lordship. I beg to mention interlocutory application in RSA 240 of 2017 for granting temporary injunction
When?
on tomorrow.
Tomorrow not possible.
on Wednesday, 9th April.
Okay. Obliged.
Top of the list item 1.
May it please your Lordship. My lord, this is an appeal, my lord, statutory appeal against a conviction under 22C of the NDPS Act. And sentence was for a period of, my lord, 10 years. My lord, on the last occasion, my lord, I have already submitted that, my lord, the main ground of appeal was that, my lord, non-production of the seized substances, seized contraband as material exhibit in the court, my lord. Regarding that, my lord, I can place certain judgment. I have already placed the judgments, my lord. Today, my lord, if your lordship permits, then I can read out, my lord.
Which one? This is Bharat Ambale.
Yes, my lord, and starting with, my lord, Jitendra, my lord, the judgment of Jitendra. Jitendra, my lord, versus State of MP. May I read, my lord? Para number 6.
Para number 6.
Para number 6. In our view, the view taken by the High Court is unsustainable. In the trial, it was necessary for the prosecution to establish by cogent evidence that the alleged quantities of charas and ganja were seized from the possession of the accused. The best evidence would have been the seized materials which ought to have been produced during the trial and marked as material exhibits. There is no explanation for this failure to produce them. Mere oral evidence as to their features and production of Panchanama does not discharge the heavy burden which lies on the prosecution, particularly where the offense is punishable with a stringent sentence as under the NDPS Act. In this case, we notice that Panchas have turned hostile, so the Panchanama is nothing but a document written by the concerned police officer. The suggestion made by the defense in cross-examination is worthy of notice. So, my lord, this was the view taken by the Honorable Supreme Court. This is the first view, my lord. So this judgment, my lord, was relied on by the Supreme Court in several other judgments, my lord, particularly in the judgment of Noor Aga, my lord. Decided in the year 2008. At para number 132. My lord. The last but not the least, physical evidence relating to 3 samples taken from the bulk amount of heroin were not also produced. Even if it is accepted for the sake of argument that the bulk quantity was destroyed, the samples were essential to be produced and proved as primary evidence for the purpose of establishing the fact of recovery of heroin as envisaged under section 52A of the Act. Now, Lordship may kindly see para number 136, next page, man. 136, next page.
46.
36. Physical evidence of a case of this nature being the property of the court should have been treated to be sacrosanct. Non-production thereof would warrant drawing of a negative inference within the meaning of section 114G of the Evidence Act. While there are such a large number of discrepancies, if a cumulative effect thereto is taken into consideration on the basis whereof the permissive inference would be that serious doubts are created with respect of the prosecution's endeavor to prove the fact of possession of contraband from the appellant. My lord, then again, my lord, there are several other judgments, my lord. The view was quite similar. In my lord,
Mr. Das are not necessary to multiply the decision.
yes. Then lordship may come to the last my lord, judgment, that is Bharat Ambale's judgment. That is the latest judgment, my lord, where the entire law regarding 52A has been discussed. If your lordship will kindly see page number 20, there also my lord Noor Aga's judgment was discussed. Page number 20.
Okay, you directly come to the ratio of the case.
Yes.
Paragraph number?
Yes. My lord will kindly see para number 37. 37.
Yes.
Section 52A, subsection 4 should not be conflated as a rule of evidence in the traditional sense. That is, it should not be construed to have laid down that only the certified inventory, photographs and samples of seized substance will be primary evidence and nothing else. The rule of primary evidence or best evidence is now well settled. In order to prove a fact, only the best evidence to establish such fact must be laid and adduced, which often happens to be the original evidence itself. The primary evidence for proving possession will always be the seized substance itself. However, in order to mitigate the challenges in preservation of such substance till the duration of trial, due to pilferage, theft, degradation, or any other related circumstances, the legislature consciously incorporated subsection 4 in section 52A to bring even the inventory, photographs, or samples of such seized substance on the same pedestal as the original substance, and by a deeming fiction has provided that the same be treated as primary evidence, provided they have been certified by a magistrate in substantial compliance of the procedure prescribed. This, however, does not mean that where section 52A has not been complied, the prosecution would be helpless and cannot prove the factum of possession by adducing other primary evidence in this regard, such as either by producing the bulk quantity itself or examining the witnesses to the recovery, etc. So in this case, my lord, the Honorable Supreme Court held that if the samples were not prepared as per 52A and samples were not exhibited, then the prosecution ought to have produced the actual contraband itself, the actual seized contraband, which ought to have been, my lord, produced by the prosecution. In this case also, my lord, that was not produced. So my lord will kindly see the ratio at page number 63, point number 5.
Yes.
Mere non-compliance of the procedure under section 52A or the standing orders rules thereunder will not be fatal to the trial unless there are discrepancies in the physical evidence rendering the prosecution's case doubtful, which may not have been there had such compliance been done. So, my lord, if 52A has not been complied with, that means the samples which were drawn and were certified by the magistrate were not exhibited, or if 52A was not even complied with, that means the samples were not even drawn, then the prosecution ought to have proved the seizure by producing the contraband itself. But however, if there are any physical discrepancies, then the entire case would be fatal. That was what was meant by the Honorable Supreme Court in Bharat Ambale judgment, as well as all the other judgments, my lord, which deal with this issue. Either you produce the samples, or if you don't produce the samples, then you will have to produce the original contraband. That is the entire seized material. Now, if your lordship will see the judgment, the exhibits which were relied on by the prosecution, none of the exhibits refer to any material of exhibit, except one, my lord, which perhaps was the Malkhana register. Other than that, my lord, there are no material exhibits in this case. That means, my lord, the seized contraband, either the samples or the actual bottles of cough syrup, my lord, were not produced by the prosecution to prove its case.
Yes.
My lord will kindly see the annexure in the appendix in the judgment, my lord. These are the list of all the exhibits that were made by the prosecution. It clearly shows, my lord, that the contraband was not exhibited as material exhibit in this case.
So while cross-examining the this complainant
My lord.
and the investigating officer, whether you had put any question to him in this regard?
My lord, the complainant was examined as PW2. PW2. My lord, he only exhibited the FIR, my lord, the signatures in the seizure list, the GD entry, the authorization letter, and the Jimmanama and 42 notice. But in his cross-examination, my lord, no such question was put.
Yes, Mr. Sharma,
My lord.
whether the Material exhibits were produced before the court.
Yes, my lord, that is, but my lord, kindly come to my lord, the exhibit list, my lord. Exhibit list, my lord, we have, prosecution have, my lord, exhibited, my lord, inventory, and my lord, the Malkhana register, as well as, my lord, the, my lord, the list of sample, my lord. Lordship will find, my lord, in the list, my lord.
Where?
My lord, my lord, exhibit list, my lord, my lord, page 42, my lord, the petition, my lord.
Of the memo of appeal?
My lord. In the, I also, my lord. In the appeal, my lord, it is page, my lord, 44. Item number, serial number 15. Then, my lord, serial number 38, 39. That is exhibited, my lord.
Serial number?
Serial number, my lord, 15, my lord. Then, my lord,
That is a Zimbanama
yes, my
of
lord,
Malkhana register.
Malkhana register.
I am asking about you the
38 and 39, my lord. Inventory and list of samples, my lord.
30?
38 and 39, my lord. Next page, my lord.
Inventory and list of sample.
Right.
No, whether you have produced the samples before the court?
No, my lord. That is,
No.
no, my lord. That
So
is,
have you gone through the decision referred by Mr. Das?
yes,
The
ma'am.
other day I have asked you to go.
Yes, ma'am. Yes. My lord, regarding my lord, Jitendra judgment, my lord. There is, my lord, the prosecution witness, my lord, turn hostile, my lord. Here, my lord, in this case, my lord, one prosecution witness, my lord, PW3 turn hostile, my lord. But my lord, others are, my lord, very consistent, my lord. And my lord, the PW1 is, my lord, my lord, independent witness. And my lord, regarding that, my lord, from the judgment, my lord, from the judgment, my lord, in the IA, my lord, page 30, my lord, para 37, my lord, that position is clearly, my lord, countered, my lord. In Rizwan Khan versus, my lord, State of Chandigarh, my lord. May I read, my lord? And my lord, prosecution has submitted that merely because of independent witnesses who have signed the seized document turned hostile, the entire the evidence of the other witnesses may be police officials cannot be discarded. It is
No,
also
that's all
submitted.
right. There is no
But
doubt
I'm not on
about it.
that, my lord.
My lord.
Now the question is, admittedly, you have not produced and exhibited the samples before the trial court.
My lord.
And having not done so, do you think that your judgment will be able to withstand the test of legality and propriety?
My lord, though my lord that seized item, my lord, not my lord produced, my lord, but my lord documents relating to that, my lord, that is exhibited, my lord. My inventory, my lord, that is also, my lord,
No,
that is certified by the magistrate, my lord.
Whether in view of the case laws referred by Mr. Das,
Yes, my lord.
your judgment will sustain?
My lord, regarding my lord Ambale, my lord, in Ambale, my lord, if my lord kindly look at the my lord para 12, 32, 33 and 34, my lord. That, my lord, the non-compliance of 52A, my lord, that is not fatal for the prosecution, my lord. That judgment, my lord, my lord, in some respect, my lord, also help prosecution, my lord. And my lord, one thing, my lord, I would like to draw your attention, my lord, that, my lord, the last flag, my lord, that regarding, my lord, request for disposal of the seized item, my lord, that is there in the record, my lord. So, my lord, it may be disposed of, my lord, before the, my lord, trial started, my lord. That document is also in the
Sir,
record.
so not, this is a criminal case here. Would be, or maybe this will not do, no?
So that that document is also exhibited, my lord.
Which document?
My lord, the request for disposal of the my lord seized item.
What happened about the samples?
My lord,
What about the samples?
samples regarding samples, my lord. I have gone through my lord the record. I have
The
not found.
samples of which you have received back from the
Yes, my lord.
FSL.
FSL, my lord.
What happened to those samples?
Yes.
Why you could not produce the same before the court? Mr. Dasar, there is a decision of Supreme Court in the year 23 and also in the year 24. There this non-production, consequence of non-production of the physical sample before the court has been discussed.
My lord.
This decision is relates to this section 52A of the NDPS.
My lord.
You find out those two decisions.
My lord. 2024.
23 and 24, two decisions are there. And this court has also relied upon those two decisions in dealing with some of the appeal. So we'll further hear you on next Tuesday. We'll keep the matters further.
My lord.
First, Mr. Estes, learned counsel for the appellant, and Mr. P. Sharma, learned additional PT for the esteemed respondent. Heard in part, this is the matter on after Tuesday. That's top of the list item.
Highly obliged.
For admission, item 2, part matter.
Finally, timing.
Pardon?
Timing, Lordship.
Timing.
Lexon, BP Bora Lexon code number 2. Lordship.
Okay.
Item 3. Part matter.
Please, your lordship.
Yes.
May it please, your lordship. On the last occasion, lordship had asked us, as per the last order, basically bring the date of joining. My lord, when the petitioner had joined, my lord, since he had abstained from my lord, from work, my lord. That order, my lord, that instructions I have received, my lord. 8/3/2021. Lordship, it is, if your Lordship sees, my lord, it is from 8/3/21 itself, my lord. He has joined from 8/3/21 as per the report of the District Elementary Education Officer Golaghat, my lord. That is the first page, my lord. The second page also the same, my lord. His claim, my lord, that he has joined on 5/5/2020 is wrong, my lord, and it is actually from 8/3/2021, second page again. First page as well as second page of the instructions. And the information has been received from the concerned head teacher. Therefore, my lord, I would like to reiterate, my lord, what I have submitted in paragraph 40, in page 40 of the affidavit in opposition which I have filed, wherein, my lord, if your lordship sees, petitioner, my lord, he has joined his duties only on 8/3/21, and accordingly, the petitioner has been receiving his salaries with effect from 8/3/21. Hence, the petitioner is not entitled to arrears salary for the period from 1/7/19 to 7/3/21 as per FR 17 so and so, as he did not perform his duty during that period and remain unauthorizedly absent without any intimation.
So, Mr. Fukan, the joining letter submitted by the petitioner herein.
Page 52, Lordship.
Huh?
Page 52.
Page 52,
Lordship. Continuation page.
Reply.
Reply. Reply affidavit, Lordship.
So, Fukan, you.
Lordship, also, I've gone through, my lord, 52, and my lordship will also see page 3 of the instruction.
Furnish a copy of the letter to him.
I'll furnish. And also, my lord will see the last, the third page of the instruction. The date there.
And that's right.
Yes, this one. Third page, my lord.
Furnish a copy to him.
3/21. This is the report of the DEO, from the DEO concerned.
What to do? You obtain instruction from your
Lordship. My lord, another thing is, Lordship, they may be directed to file a detailed affidavit because, my lord, there are certain documents, Lordship. They have mentioned in my in other letter, Lordship. Kindly will look at page 35, Lordship. They have mentioned about school register and other things, Chief, and they are not disputing that, Lordship. You are under treatment till February 2020 for the TB, Lordship. And regarding, Lordship, this letter, page 53 letter, Lordship, here this is from Director of
No,
Elementary.
in the page number 35 also, at
Lordship.
serial number 2, it has been mentioned that he resumed duty on 8/3/2021.
Lordship.
Exactly, ma'am. And my lord, one more thing I would like to point out. If your lordship comes to page 40 of the affidavit in opposition, there, my lord, if your lordship sees, he always mentions regarding TB leave. TB leave was, my lord, the petitioner has to resume his duties immediately after availing TB leave up to 36/19. So up to 36/19, he was on TB leave. No one is denying that. The question comes thereafter, my lord. That is 1/7/19 to 7/3/21. He is claiming area salary from then, but actually he was not. He was my lord, unauthorizedly absent, my lord.
That's why I'm
And
submitting,
therefore, my
Lordship.
lord, we have produced. On the last occasion, and there was a confusion regarding his joining, and lordship had asked us to bring as to when he had joined. So, and therefore, the instruction has come, and as per his own record also, it's 8/3/21. So therefore, from 8/3/21, he has been receiving salary. But prior to that, he has not been receiving since no work, no pay comes in. No work, no pay. He was not on duty. So that therefore he has not received salary. So he cannot claim, my lord, the salary at that for period from 1/7/19 to 7/3/21.
And
That is my humble
that's why I am submitting, lordship. Kindly have a look at page 50, lordship. It is a vernacular letter, lordship. And from Khanda Patami, Block Elementary Education Officer to the to Chandrakanta Sharma, lord. Here, lordship reflects about a certificate issued by Joint Director of Health Services, lordship. Page 50, lordship. So vernacular, on last 5 line, lordship. 6 line from Kintu. May I read in Assamese, lordship? কিন্তু ওপৰত উল্লেখিত 2 নং প্ৰসংগক্ৰমে আপোনাক জনাব বিচাৰিছো যে যুটীয়া সঞ্চালক স্বাস্থ্য বিভাগ গোলাঘাটৰ পৰীক্ষা বোৰ্ডৰ প্ৰমাণ মতে 8/6/2019 পৰা 29/2/2020 তাৰিখলৈকে 18 মাহৰ উপৰিও অতিৰিক্ত মুঠ 239 দিন জিৰণি অতিক্ৰম কৰিলে। And it is not disputing that he was under treatment since 29/2/2020, lordship. They are claiming that he was under treatment since June 2019, lordship. And after that, lordship, a letter was issued to him on 1/3/2020 and 19/3, lordship. Accordingly, he has joined on 5/5/2020. And this letter, lordship, perhaps I will take instruction, but not my submission is that perhaps because, my lord, after his joining 5/5/2020, the school was under close, lordship, because of the prevailing situation of COVID-19. Because till December 2000, lordship, 20, the school was closed, lordship. And that is that will reflect from the school register, lordship. I have seen the school register because, my lord, school register was supplied to the petitioner after his RTR application, lordship. And I have seen personally that, my lord, till December 2020, the school was closed. There is no endorsement of signature of any other teachers, lordship. Perhaps, my lord, after the reopening of the school, after the situation was good for the COVID-19, lordship, he has joined again, my lord, on 8/3/2021, lordship. That endorsement, perhaps this letter regarding that, lordship. I am not sure. I will take instruction, lordship, but, my lord, my prayer is that, lordship, they may be directed to submit a detailed, lordship, affidavit. Because in the present affidavit also, they have submitted that if required, they will submit detailed affidavit, lordship.
My lord, we have given the instructions, proper instructions, which is a report. Plus,
Because
my lord, we have
they have
regarding the
not- they have not
COVID-19
an-
thing.
They have not
at-
annexed the,
at
lordship,
page-
certificate issued by Joint Director of Health Services
At
and
page
other
what-
various reports.
No, why do we have to bring Joint Director of Health Service, my lord? They are some different department. We are concerned with, my lord,
Because it was supplied to them, lordship, under
and my
their
lord,
requisition.
my
it
lord,
was
he's
supplied
saying
to them.
regarding COVID-19, my lord, in the page 40, I have already said, my lord, that it started from March 2020 onwards. So before that, this is a question of before that, my lord. I mean, sorry, after that. So the question doesn't arise only, my lord. He already was my lord, without authorization. He was absent from 1/7/19 to 7/3/21. That is there. And
And
my
other-
lord, before that, my lord, he was on TV leave, my lord, from 30 till 36/19. So the moot question is, after 36/19, why was he unauthorizedly absent from duty? It was his duty, my lord, to inform the
No, Mr. Pon, are you sure that at the relevant point of time, the schools are closed?
I know,
On account of
that also I'll get, my
COVID-19.
lord, then. Again, I'll get instructions regarding that also, my lord. Last time I had got regarding the date, my lord, as to when he had joined. Now it is crystal clear, my lord. He has joined on 8/3/21 from his own record also, plus the new record which instruction which the DEO has given from the report. Further, he wants more information, my lord, we'll get the register only, my lord.
Better, Mr. Pokon, you do one thing.
My lord.
You file detailed affidavit incorporating all those things.
May I submit another thing, lordship? Other day, lordship, they were instructed to take another instruction, lordship, regarding the letter, lordship, page 53 letter, lordship. Here, lordship, at last second paragraph, lordship, it was directed by the Director of Elementary Education to the District Elementary Education regarding that without regularization of absent period, how the teacher concerned was allowed to join and release his salary, lordship. Second last paragraph, last 3 lines, lordship.
Lordship, on the last occasion, this particular thing
It
was
was
not.
raised, lordship. It was
Lordship,
raised.
Lordship sees the order, it is not there, my lord. Only the joining part was Lordship had given us direction. If your Lordship checks the order, last order, it is, my lord, this is my lord, this thing statement.
Okay, you file detailed affidavit.
I'll file a detailed affidavit.
Or otherwise, Lordship, may I pray that because my lord, everything will be clear, Lordship, if a detailed hearing will be conducted by the Lordship.
Heard Mr. R. Patan, learned for the petitioner, and Mr. A. Patan, learned something counsel for the respondent. Person to order dated 24/3/2025, Mr. Patan has obtained a written instruction from the respondent authorities and submits that the petitioner herein joined his duty on 8/3/2021 as per report of the DEEO Gulagat. In view of the letters enclosed along with the report of the DTO. No, along with the report of the DEEO. In view of the written instruction obtained by Mr. Pokon, it is provided that Mr. Pokon shall bring on record the said instruction by filing a detailed affidavit. In the meantime, Mr. Parek Pokon, learned counsel for the petitioner, shall also obtain necessary instruction in respect of his joining his duty on 8/3/2021. This is the matter on 30th after vacation. After vacation. Not sure, but 30th. 28th of
Obliged, Lordship.
as part of. And the written instruction plus report of court today shall be part of the rest.
My
Obliged.
lord, I've given a copy to the, I've given.
I received.
Detail.
File number 4.
May I please, your Lord.
Yes.
So this revision petition is arising out of an order passed, an amendment application lawsuit, amendment of the claim at a belated stage lawsuit. When the PW has given cross started after that loss. Let me satisfy lawsuit.
Where is the MPU order?
Lawsuit.
Page number?
102. Lordship, I'll go to the impugn order, Lordship, in detail. Lordship, before that, Lordship, some fact, Lordship. I want to show your Lordship the facts. Because then Lordship will read the interim order, the order passed by the court. Lordship will get the thing at what stage they have come. Lordship, may please come to Annexa 1, page 16.
Yes.
This is already amended plain. This is a suit of 2013. So this amended plain is filed on 4/3/2020. So there is already an amendment. Lordship, may please come to page 17.
Page?
17, 17.
Yes.
This is a suit for partition and permanent injunction. A suit for partition for recovery of possession along with the permanent injunction. Lordship, get it. This suit, Lordship, my client appeared, file a written statement, Lordship. That written statement is at page 26. Lordship, the whole, all detail, Lordship, giving all the facts and in the written statement. Only one paragraph I'll read, Lordship, from the written statement for the purpose of this amendment, Lordship.
Written statement is at page number?
It is at page 26. Permission not to possession.
There are 17.
Lordship, may please come to. Lordship, may please come to page 34.
Yes.
Page 34, last 4 line. Thereafter, the defendant claimant has applied for building permission for construction of multi-story building over the opposite plot of land before the authority of Guwahati Municipal Corporation, Panbazar, Guwahati 1. Upon being verified, all the record and the spot verification by the authority GMC, and upon being satisfied with the complaint from any angle, the authority of GMC issued a NOC number so and so for construction of 6-storied building. Lordship, get it? Lordship, take note of this because this is my whole crux of the matter, Lordship. And when we have filed this written statement, Lordship, 10/7/2014. Lordship, it is the affidavit. Lordship can see at page 43 of my written statement. There should be a limit of delay, Lordship. It is page 43, 11th day of April 2014, Lordship. It is 2014. Suit is of 2013. Now, Lordship, the plaintiff has filed a written statement against my counterclaim. So my statement is very specific that there is a 6-story building and all that permission, everything is there, Lordship. She has gone ahead with the now, Lordship, the plaintiff at a belated stage, Lordship. In the year 2021, Lordship, may please come to page 51. Page 51, Lordship. In the year 2021, it is a suit of 2013, the plaintiff filed an injunction application, Lordship. Now, what injunction? What is the prayer? Plaintiff wants that not to alienate and transfer the newly constructed area over the scheduled land till disposal of the suit. Injunction. In the 21, suit of 2013. Now, Lordship, please come to the schedule at page 58.
Page
58. Highway. A plot of land measuring so and so and a 2-storied extended another 4-storied, total 6-storied, Lordship. It's an admitted position, Lordship. And it was signed on 29/9/2021, Lordship. This affidavit. This miscase was filed on 29 September 2021. Now we have filed our objection. In the objection, we have specifically stated that our building is complete and everything. What happened, Lordship? Now, Lordship, the record is not there before your Lordship, but I can show your Lordship along with the injunction application, this I have taken the certified copy, Lordship. Along with the injunction application, they have given this document in the court. And this document shows that my 7-story building is already complete. It is there. That is why I have taken the certified copy, Lordship, from the court. It is the signature and everything is there from the court. Lordship will call for the record. Lordship will see.
no, is it necessary to call for the record?
No, Lordship. This is but the only, no, it's not necessary. Just Lordship, if you Lordship wants, Lordship can call for. I have shown, Lordship, my building is there. This is his document, Lordship, before the court that my building is complete already. In my written statement, 2014 itself, I have written that there is a permission, ground plus 6. It is all there. Now, Lordship, at page 76, Annex 7. This is an application under Order 6, Rule 17 file in the year 2023. 23/3/2023, Lordship. Lordship, CD paragraph 1. The instant case is fixed for commissioner report that the plaintiff instituted the present suit for partition, recovery of possession along with the prayer for permanent injunction, which is pending disposal. Then all this statement lordship and what they want to do now by this at para 18. That the plaintiff beg to submit that prior to filing of this instance suit, there is two-storied RCC building over the scheduled land, and during the pendency of the suit, defendant again extended another four-storied over the scheduled property. Now the building is six-storied. Lordship, that is why I have read that paragraph, Lordship, in 2014 itself. I said that it is a six-storied, Lordship, and their application is there, their photographs is there before the court. Now with that, what they want to do is at page 83. That as the plaintiff is a legitimate legal heirs of late so-and-so after the death of so-and-so, the plaintiff become the absolute owner over the scheduled land by right of inheritance. During the pendency of the suit, the defendant trying to grab and deprive the so-and-so, there was no interim order 2013 itself. Suit started. No interim order. 2021 only order 39, rule 1 and 2. That too not to transfer, not to alienate, prayer and to status. Now they want to sense all these things. And we have filed our objection, Lordship, there. Now, Lordship, in the objection, Lordship, at order 6, rule 17 objection is at page 90, Lordship. Lordship, page 90, Annexa A. My whole thing is there in paragraph 3, Lordship, my objection. Paragraph 3 at page 91. Early slowly. The suit is at the stage of the cross-examination of the PW. And as such belated stage, the application for an amendment is not maintainable. The alleged extension of the scheduled property was not certainly done overnight. And why she was silent and allowed the construction? The plaintiff has miserably failed to explain the delay for filing the amended application, merely by stating that during the pendency of the suit, the defendant extended the forced storage in the scheduled property is not sufficient, as because the plaintiff has filed the instant application for amendment after long delay since the commencement of trial. The construction of six-story building was completed in 2018. The plaintiff was fully aware that the defendant completed the construction of the building in 2018, but she remained silent. After more than 4 years of completion, the plaintiff filed the instant application for amendment. There must be due diligence and sincerity in filing the application for amendment, but no due diligence has been shown by the plaintiff. This application for amendment. Page 98, Lordship, now. Before that, Lordship, if Lordship will allow, Lordship, I will read one paragraph, Lordship. She was never there, Lordship, page 96, para 13. That the statement in paragraph 8 of the amended application are not true and correct, and the same are denied by the defendant. In this regard, it is stated that plaintiff was well acquainted about the mutation of the name of the defendant. The defendant and his wife neither assaulted the plaintiff physically nor thrown her out from the scheduled land. In fact, the plaintiff has been residing somewhere else in 1979 till date. After received the summons from the Honorable Court in connection with the above noted suit, the defendant has come to know that the plaintiff opposite party is residing in Pupsaronia, Guwahati, care of so-and-so, so-and-so, so-and-so. The whole story is here only, Lord. This lady has insisted her to file this suit. She is a PW2, already filed, Lordship, this lady. She has kept her that be here, file a suit, I want this property. Because it's a prime property in Tokobari, Guwahati, Lordship. Plaintiff in the plain nowhere said that is father's land, no patta, no zomabandi, nothing, Lordship. My clients own hard-earned money, Lordship, invested my client's property, Lordship. She said, my father died, my name be mutated. Somehow her name was mutated, it was cancelled. DC has given a detailed order. Then, Lordship, where are? Page 98, Lordship.
Para 19.
Para 19. Page 98, para 19. There is statement made in paragraph 14 of the amended application are fully true and correct, and the same are not admitted by the defendant. In this regard, it is stated that the suit is pending for last 9 years, 5 months from the date of the institution of the suit. The construction was not done overnight. If the construction was illegal, why the plaintiff remained silent for such a long time? The plaintiff sought to have moved this honorable court immediately after starting the construction. It was not done. Lordship, now this judgment, impugned judgment, is at page 102. It's a long judgment written, Lordship, giving schedule and everything, Lordship. The main thing was not considered. Let us read it from page 105. Initially, the whole petition was, he has dictated the whole amended application, Lordship. Page 105. The defendant, opposite party, defendant number 1 filed written objection in which the opposite party admitted the construction of the 6-story building over the scheduled property, but stated that the construction was completed in the year 2018 and the plaintiff petitioner fully aware of it, but they remain silent. It is after the more than 4 years of completion of the said construction that the petitioner instant application of it is also stated that the amendment and all that, what I have already read, Lordship, he has recorded all this. And then I have read this paragraph, Lordship, in my objection, Lordship. He has recorded that. So he knows that all this, it was 2018, it was constructed and all that. Now, suddenly, Lordship, he has come to a finding at page 107. Lordship. Oh, Lordship, before that, Lordship, 106. That what state the suit is now. Page 106. He has noted that also. Page 106, top line. The case is at the stage of cross-examination of PW. The two conditions required to be fulfilled for amendment of the plain, whether the amendment is necessary for determining the real question of controversy, whether the amendment can be allowed without injustice to the other party. According to him, only these two conditions is required. LIC and all that has given, the Supreme Court, even T24 has given all the conditions for amendment at a bill at a stage. At least first is due diligence, Lordship. In the application, there is not a whisper regarding the due diligence. And in the impugned order, there is not a whisper regarding the due diligence, Lordship. Now, what is this finding after all this, Lordship? At page 107.
সিহঁতে কৈছে ছয়টা ফ্লোৰ অলৰেডি আছিলে ইন লিষ্ট কেছ ইয়াতে কৈছে যে এক্সিডেণ্ট কেৰেক্টাৰ চেঞ্জ কৰি মানা কৰি তাকে কৰি
Now, what is the finding, Lordship? Let us see. Page 107, third paragraph. It is seen that the two conditions necessary for the amendment is allowed or fulfilled. The case being one in partition, it would be absurd not to allow intrusion of the two additionally constructed floor on the suit property standing on the suit land in the plain. That apart, the defendant was already under the order directing him not to change the nature and character of the land until disposal of the suit. Lordship, this order is of 2021. 2022. Lordship, it is in the next paragraph, Lordship will get his date also, order date. And when the defendant has changed the nature and character of the suit, despite the restraint order, in the interest of justice, which demands that the said amendment to the plain is to be made. It is the defendant who acted in violation of order dated 17/12/2022. Lordship, 6-story building After the injunction order is 17/12/2022 in a suit of 2013, invaluable. And by only saying this, he said that this is in violation of the injunction order, so amendment is allowed. Lordship, for the first time I have heard, Lordship, someone will violate the injunction order, so he will amend the claim.
Injunction application, page 58. Why is
Now, page 58, Lordship, they himself has said that he has not read anything, Lordship, while passing this order. Page 58, Lordship, for at the cost of repetition, I have shown your Lordship. Page 58. Their application, Lordship.
No.
Injunction application. Page 58. Schedule. A plot of land measuring so and so and that 2-storied extended another 4-storied, total 6-storied. That is on 29/9/21 itself, they know. And before that, in my written statement in 2014, I specifically made a statement in my counterclaim also. Now, at this stage, this order is passed, that claim to be amended, Lord. Now, what is the case about? According to the plaintiff, she is my sister, and this is our paternal property, so she should get a share in the property. And my case in the written statement and the counterclaim that this is my hard-earned money, this is my own property, not my father's property, and creating all this problem by the sister. She, in the first amendment, bought my 2 other brothers and all that. It is all ex parte. They have not come because they know that they have no right there. It is all ex parte against them. She tried to brought them to the suit. She may file an application for amendment, but all of them.
Mr. Sharma, there is a decision of Supreme Court in the year 2024.
LIC.
Where it is stated that all amendments should be allowed.
LIC laws.
Sanjeev Bill.
Lordship,
I
Sanjeev.
remembered it.
Yes,
petition.
Lordship, on relying on that, Lordship has also passed the judgment, Lordship. There is a judgment of your Lordship, but that is not my case, Lordship. There is a embargo, Lordship, in that judgment itself, Lordship. When and how. Not all amendment, Lordship. I'll satisfy your Lordship on that. It is the Life Insurance Corporation versus Sanjeev Builders Private Limited, Lord. That I'll satisfy your Lordship. That is their Lordship. That it is the at the last page, Lordship, 2022-16 SCC. It is started at page 1, and in the last page, page 36, Lordship. Photo code. In the page 36, I'll just read and hand over, Lordship. 71.10, where the amendment changes the nature of the suit or the cause of action so as to set up an entirely new case. Foreign to the case set up in the plain, the amendment must be disallowed. Where, however, the amendment sought is only with respect to the relief in the plain, and it is predicted on the fact which are already pleaded in the plain. Ordinarily, the amendment is required to be allowed. That Lordship is very correct, and after relying on this, Lordship has passed his judgment, Lordship.
That is for amendment of legislation.
But then, Lordship, there are Supreme Court judgment, Lordship, that if Lordship, they have bought this thing, Lordship, I do not know. Itu কি হলো? এটা সিরিয়ালি আছে না? Itu কি?
দেখাবো 2024 ডিসেম্বর।
টিপিসি কি বলতে জানো না? before I read the judgment, Lordship, let me read the provisions, Lordship, at the amendment. Because after the amendment of CPC, now Order 6, Rule 17. CPC খন দিব নেকি? I'll read.
Order
Yes.
6, Rule 7.
Yes, Lord.
Yes.
Lordship, may I read? The court may, at any stage of the proceeding, allow either party to alter or amend the pleading in such manner and on such term as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties, provided that no application for amendment shall be allowed after the trial has commenced. In our case, issue long back, 2014-15 issue. Then PW has filed, cross-examination started. Provided that no application for amendment shall be allowed after the trial has commenced, unless the court come to a conclusion that in spite of the due diligence, the party could not have raised the matter before the commencement of trial.
On that point also, there is one decision of Supreme Court, authored by Justice Surjakant. Is it with you?
Surjakant
Yes.
judgment, Lordship.
Yes. That is also recent judgment, due diligence.
Due diligence. Okay, due diligence judgment, there are several due diligence judgment, Lordship. I'll read all the judgment. And Surjakant judgment, Lordship, I'll bring, Lordship. Now, Lordship, I think Lordship will get there is a judgments of the Supreme Court, Lordship.
24.
Lordship.
2024 বাস্তবে
Lordship, it is
Paragraph number.
2024, 3 SCC
Paragraph number.
705.
Para 10.
Paragraph 10, Lordship.
Yes.
In the only thing, Lordship, in the facts of the case, paragraph 2, Lordship can see this is also a suit for partition. This case. Paragraph 2, it is the mentioned, Lordship. And now they want to do it as a from the declaration and all that things they want. Then they file in the 4.5 and all that. Lordship, I'll straight come to paragraph 10 at page 711. The proviso to the Order 6 Rule 17 CPC provides that no application for amendment shall be allowed after the trial has commenced, unless the court come to a conclusion that in spite of the due diligence, the party could not have raised the matter before the commencement of the trial. In my case, Lordship, in the written statement and all that, it is already there, injunction application, long back it is there, everything. Facts of the case is different, Lordship. Sometimes maybe here and there some judgment, Lordship, that with the facts of the case, Lordship. In my case, Lordship, facts of the case is different. In the application for an amendment, that due diligence was there at the time of filing of the suit is not seeking relief paid for by way of amendment. All what is the pleaded was oversight. The same cannot be accepted as a ground to allow the amendment in the pleading at the fake and every trial, especially when the admittedly the facts were in the knowledge of the respondent number one and two, as in our case, Lordship. If she is my sister, long back 2014, I said it's a 6-storied building. She says she's staying there. And now after 8 years come for an amendment that I have completed six story. Now she wants to amend.
So due diligence was not there.
Not there. Not there, definitely. And Lordship, the pleading of the parties, Lordship. Pleading in the injunction application schedule. She herself has said that the 2-story extended another 4-story. These things are not there, and the word due diligence is not there in the application, not in the order, impugn order. Somebody have to say that after the due diligence.
So
Yes.
the proviso of the said order has been ignored.
Yes.
Yes. That is my case. Lordship.
Yes, Mr. Krishnadra.
Yes. Lordship, may I place the other judgment after Lordship? Okay, Lordship. Lordship. Lordship, give me 1 minute, Lordship, welcome.
Lordship, for a moment, I would like to take your Lordship for to the injunction order passed by the Nird Court below, which is at page 71. From where it is, Lordship, clear that I am the sister of the petitioner here, Lordship.
No,
May I
there is
read
no
it?
dispute about it.
No, there is a dispute, Lordship. According to them, the property is self-acquired. But as per the injunction order, the property belongs to my father. And after my father
No,
died,
maybe, but by this injunction order, the court has not decided who is the owner of the
yes,
property.
that is true. That is not decided, but there is an observation, Lordship. For a moment, Lordship, page 73. Not paragraph, Lordship,
Page number 73.
73.
Yes.
Second paragraph, Lordship. The record reveals that suit has been filed by the plaintiff against the present opposite party, as well as the legal heirs of her another brother, late so and so, for partition of ancestral property. Perusal of the Jawamandi and the Sita Fight Exhibit 1, 2, 3, and 4 privacy reveals that the name of present OP is, along with other two brothers, namely Anil Kolta and Uttam Kolta, are mutated in the place of their father, late Gojendra Kolta, over the suit land, depriving the petitioner. Thereafter, on application being filed by the petitioner, her name also mutated along with her brother Rajan Rajkumar Kolta and over the ancestral property, Lordship, which shows after the death of their father, the name of the respondent here in the plaintiff in the suit has been not mutated. And being the position that there are 4 siblings.
No, we are not concerned with that.
Yes,
We are only
for
concerned with whether
for the
this
facts, Lordship.
amendment petition was allowed in accordance with law or not.
Yes, Lordship. For the facts, Lordship, one brother was unmarried and he died. And the other one got after he got married, but he got divorced, and he also got died. So after the notice was issued, they did not turn up because both the brothers had and the lady, the wife of the second brother who has already got divorce order, she did not come up to contest the suit because she already left her husband. Now, Lordship, coming to the injunction order, Lordship, at page 102. I will straightaway take your Lordship to page 104.
Yes.
May read it for a moment, Lordship. It is stated in the petition that the petitioner plaintiff has filed the suit for partition, recovery of possession and permanent injunction. During pendency of the suit, the OP defendant number illegally constructed another 2 floors over the suit property. After coming to know that the OP is intending to alienate transfer the newly constructed area over the scheduled land to a third party, the petitioner plaintiff immediately filed an application under Order 39 Rule 1 and 2 Radio Section 151 of CPC granting injunction restraining the OP defendant from alienating transferring the newly constructed area over the scheduled land until disposal of the suit. Miscase number so-and-so was registered, and after hearing both the parties, this court right ordered that so-and-so granted an interim injunction restraining the OP from alienating transferring the newly constructed area over the suit land and also from changing the national character of the land until disposal of the suit. The defendant, having full knowledge about the miscase, again illegally constructed another 2 floors over the scheduled property. It is stated that prior to filing of the instance suit, there was only a 2-story RCC building over the scheduled land, and during pendency of the suit, the OP defendant number extended 4 floors over the scheduled property. It is further stated that due to typographical mistake in para 3 of the plan, the revenue village is mentioned as Sohor Soronia, Guwahati Part 2 under the scheduled portion. The revenue village is mentioned as Sohor Soronia, Guwahati Part 2 under Moza Beltola instead of village Sohor Soronia, Guwahati Part 2 under Moza, Guwahati. It is a bona fide mistake, hence the prayer of the same is considered. It is important, Your Honor. Now, the OP defendant number 1 filed written objection in which the OP admitted that construction of 6-story building over the scheduled property was stated that the construction was completed in the year 2018, and the petitioner plaintiff was fully aware of it but remained silent. It is after more than 4 years of completion of the said construction that the petitioner plaintiff filed an instant application for amendment. It is also stated that the amendment, if allowed, will introduce a new cause of action and also new issue will come up, thereby changing the national character of the suit. It is further stated that the instant petition has been filed at the stage of cross-examination of PWs, and at such belated stage, the petition for amendment is not maintainable and therefore prayed that the petition is rejected. The case, my learned student friends already read this out, Lordship. The second, it is seen that the instant suit is filed for partition, recovery of possession, permanent injunction. The petitioner plaintiff has claimed ownership over the property by virtue of being legal heirs of late Gajendra Kolita, who was the absolute owner and recorded patradar of the plot of land measuring so-and-so over the scheduled property is standing. The defendant is one of the legal heirs of late Gajendra Kolita. Admittedly, the petitioner plaintiff does not reside in the suit property. It is seen that the petitioner plaintiff filed his suit in respect of the said land along with 2-story RCC building on it. It is also seen that during pendency of the suit, 2 more floors were extended by the defendant and by order dated so-and-so in miscase number so-and-so that this court extended the OP from changing the national character of the suit land and from alienating the constructed building. Now the amendment sought for is with regard to extension of 2 more floors admittedly constructed by the OP defendant. Although the OP defendant pleaded that the same was constructed in the year 2018, the OP defendant, important, did not so to bring any evidence in support of this contention. On the other hand, the OP defendant contested miscase and also claimed the property to be his self-acquired property, but made no mention about the construction of 6-story building over the suit property. That being so, the amendment sought for the plaintiff with respect of 6-story building is necessary, as the 6-story building is standing on the land over which the plaintiff petitioner claims to have ownership rights by virtue of being legal heir. Further, the amendment will prevent multiplicity of suits. Of the other 2 amendments sought, one is relative insertion of new prayer, which is consequential and conjunctive to the proposed aberment, and the other is amendment of a typographical error, which can be allowed. It is seen that the 2 conditions necessary, Lordship has already raised. To my respectful submission, Lordship, the Honorable Supreme Court is also clear and the provisions is also clear that amendment can be sought at any stage, and if there is a delay, there are in instances.
How do you satisfy the requirement of that proviso?
Due diligence.
Due diligence.
Yes, Lordship. There is, when the suit was filed, for that moment, I would like to take your lordship for in the WS filed by the petitioner lordship as page 34. The paragraph 26 lordship. Yes. That the defendant counterclaim begs to state that the name of the defendant counterclaim has been rooted in the revenue records since the year 1990, and accordingly he has been paying land revenue over the aforesaid plot of land till today. Thereafter, a defendant counterclaim has applied for building permission for construction of a multi-story building over the aforesaid plot of land before the authority of GMC Panbazar so and so. Upon being verified all the records and spot verification, the authority GMC has been on being satisfied without complaint from any agencies, issued NOC so and so for construction of 6-story. NOC was issued, yes, admittedly NOC was issued for construction of 6-story, but at that point of time there was only two-story building when the suit was filed, and when the another 4-story was constructed on the strength of this NOC, the plaintiff respondent area lordship has filed an injunction petition because those floors were constructed to sell to a third party, and upon being satisfied, the court has passed the injunction order, and that order was not challenged. So that order attains the finality to my limited knowledge. And lordship, after that, when since the suit is for partition of the scheduled land along with the RCC building, since the 4-story building is a part of the same building which was already mentioned in the schedule of the plan, so lordship, the amendment is required, and for which the learned court below has rightly allowed the amendment of the plan. So the plaintiff, after getting the injunction order, has filed this application for amendment. So since admittedly she is not staying in the scheduled property, she is staying in somewhere else. So during when the construction was going on, she was not aware because she could not go and visit the place on a day-to-day basis. So let's say admittedly there is some delay, but due diligence was there. So after getting injunction, or immediately after getting the injunction order, she filed a petition. After getting injunction, there is no delay in filing the amendment. So in my response submission, there is a due diligence, and the learned court below has rightly passed the order in favor of the plaintiff for allowing the injunction. And to my limited knowledge, if the injunction amendment is allowed, the necessary won't be sense, because the additional 4-story which is allowed to be inserted in the plan, that is a part of the already part of the schedule land which was in the pleadings.
So now in the WS, in the schedule of the property, it has been mentioned about 6 stories building.
Lordship, in the plan, Lordship will find my schedule at page 24. For a moment, Lordship, page 24. The schedule, Lordship. Have Lordship got it? Page 24, Lordship.
Page number 20?
24, Lordship.
Yes.
The schedule, you have also got it. A plot of land measuring about so and so, and a 2-story building measuring about 1 square feet covered by dark number so and so. Lordship. At the time of filing of the suit, there is admittedly there is a two-story building, and at that point of time, in the schedule it was written as two-story building, but in the later stage, during pendency of the suit, another 4 stories has been constructed, which Lordship has got in the schedule of the injunction petition at page 58.
Oh, you come to the WSCOM counterclaim at page number 35.
Yes, Lord.
Here, permission was obtained for construction of six-story RCC building.
Yes, Lordship. Permission was obtained, but at that point of time, Lordship, the down below, Lordship will find the NOC for construction RCC multi-story building over the aforesaid plot of land having super build-up area of ground floor so-and-so and the first floor so-and-so. Though the GMC authority has given permission for construction of the aforesaid build-up area over the said plot of land, the defendant counterclaim started construction of multi-story building over the aforesaid plot of land and is approximately 918 square feet for ground floor and the first floor following the rules and regulations of GMC. With approved plan and two-storied construction G+1 has already been completed. At that point of time when the WS was filed, there was only G+1 which was completed, which was admitted by the petitioner herein and the defendant in the suit. The allegations made by the plaintiff opposite by defendant counterclaim claim the opposite opponent has jointly constructed both the floors is totally false, misleading one, and the along construction so and so. So, Lordship, at the time of filing of WS, only G+1 has been completed, and admittedly, on the part of the from the WS also it is clear, Lordship, and from the objection during pendency of the pendency of the trial of the suit, the another 4 story has been done by the petitioner, Lordship.
Okay. Lordship, may please come to page 106. If the point for determination is not there, how Lordship will avail this judgment? Page 106. What is the point for determination? Top. The case is at this stage for cross-examination of the PW. The 2 conditions request to be fulfilled for amendment of the claim. That is, whether the amendment is necessary for determination of the real question of controversy and whether the amendment can be allowed without injustice to the other party. That is the point for determination. Where is the CPC has gone? All the CPC has said that the due diligence, delay, all these things. Where is that point for determination? So only the court has determined these 2 points only. And Supreme Court in the one after another, Lordship, there are several judgment, Lordship, no one, but there are several judgment, Lordship, that for the amendment, what is to be looked into? Lordship, 2020-11 SCC, page 549. It is the last paragraph, 1 page judgment, Lordship, last paragraph, paragraph 8. There have been no finding of the court that the court is satisfied in spite of the due diligence party could not introduce amendment before the commencement of the trial. The order of the trial judge is unsustainable. The High Court has not debated the above aspect of the matter. In view of the aforesaid, we allow the appeal, set aside the order, the High Court as well as the civil judge. The amendment application stands dismissed. This is the Supreme Court judgment, Lordship. There are various judgment, Lordship, on that point, Lordship. There is judgment, Lordship, 2006 also. I can read the paragraph 55 only. Due diligence, Lordship. Yeah. 2006-12 SCC, Lordship.
No, not necessary.
Para 1. On the point of due, there are several judgment, Lordship. Lordship can see. At page 13, Lordship. Para 35 and 36. Then after the amendment, now what is the CPC? Then after the commencement of the trial, whether court can allow and all that. Then Lordship at page 14, top 3 line, the application for amendment being allowed after the trial has commenced, unless the court come to a conclusion that in spite of the due diligence, the party could not have raised the matter before the commencement of the trial. What is that? Then at para 55, Lordship, 54 at page 17, Lordship. Para 54, last 4 line. Under these circumstances, non-seeking of the appropriate amendment at the appropriate stage in the manner in which the law disentitled the appellant to any relief. The amendment, in our view, also seek to introduce a totally new and inconsistent case. We have carefully perused the pleading and the ground which are raised by the amendment application prepared by the in exhibit 95 and so and so, and the exercise of the due diligence matter could not be raised by the appellant. In the circumstances of the case covered by the Rule 17 of Order 6, and therefore relief deserved to be denied. The grant of amendment at the belated stage, when the deposition and evidence of 3 witnesses is already over, as well as documentary evidence is already tendered. In our case also, let's say cross-examination started, PW has given, and in the first PW says he do not have any document that this property is of his father. That is the evidence, Lordship, of the PW1. And the PW2, that lady, Lordship, who is staying there, now she has come, she said, I have no knowledge about the property. Because she is staying there, I am here to give the evidence before the court.
There is no escape from the schedule, page 50.
And Lordship, they cannot escape from their own schedule at page 58, Lordship. That is of 21. What is due diligence, Lordship? There are another 4 stories constructed. Their own schedule they have said, Lordship, at page 58, injunction application. Page 58, Lordship.
End of the matter.
Is the end of the matter, Lordship. That is, if that is due diligence, Lordship, I am sorry, Lordship. Page 58. Their own affidavit, their own schedule, a plot of land measuring so and so, and the 2-story building extended another 4 story. That is on which date? 29/9/2021. They know. Now my learned brother is saying that after the injunction order only, now they have immediately filed the application for amendment. And this is their application. And he said that the learned judge has said that I have not given injunction, I'll give evidence, Lordship. The photograph is there before the court of the 7-story building. I have taken the certified copy from the record.
Okay. We'll pass the order.
Lordship.
Lordship, here in the last item also, one submission also, section 52 of the Transfer of Property Act.
Pardon?
Section 52 of the Transfer of Property Act, which is list appendix. That point may be considered, Lordship, while from 52. And Lordship, I will be relying on some judgments, Lordship, which I will hand over to the court master during the within some time, Lordship. And Lordship, the reviewing due diligence, since 2013, there is due diligence on my part, Lordship. So I have filed a suit in the year 2013. That will be my last submission.
Finding item number 2.
There were some students. On the last occasion, instructions were sought whether they can consider or not, because we are within the law, within the regulation. The regulation permits 3 chances. We have given the 3rd chances as per the court's order. Now they are not declaring the results. And as per the regulation also we are covered, as per the UGC regulations we are covered. So therefore only the results is pending. Otherwise we have only one subject. Otherwise we have cleared all the subjects in all the semester. one subject in the first semester, we was backlog, which have already appeared, now only the results. On the last occasion, your lordship had directed the respondent whether they can consider as per the regulations or not.
Yes, Mr. Day.
My instruction is this, my lord, under the regulation, the university cannot allow them because, my lord, there is a chronology when to appear in the backlog examination. My lord, they first appeared in 2017, then 2018, and the last they were to appear in 2019. They did not appear. 2020 also they did not appear. They appeared, we were going to appear in 2021 only. Well, so my lord, under the regulation and they are not, they cannot be permitted to appear in the examination.
So is there any provision for relaxation?
Relaxation, no provision, my lord. No provision for relaxation. My lord, and this regulation, my lord, it was impugned in another case. My lord, the validity of the regulation. The validity of the regulation has been upheld by the division bench of the Supreme recently.
Lordship, I was appearing there. I have brought the judgment, but the claim of the petitioners, that is a different case. That are students concerning the fourth attempt. The facts are also different from this case. And in the last paragraph, Lordship, I'll just read out. I have brought the judgment. I'll give it, hand it over. It is made clear that this court has only examined the question of validity of the regulation 5.3 and 19.6 of the board and regulations in this judgment and order, and has not examined the merit of the claim of the petitioners for getting one more chance, which is pending consideration before the writ court in WBC 828. Therefore, the judgment order will not affect the said claim of the petitioners. That is a different case, and facts are also different because we are claiming third sons. They are fourth sons, Lordship. Fourth sons, regulation does not permit. And regarding the question that we have missed the chance, that is also taken in the affidavit, and I have replied to the same. 19.2 covers Lordship, that situation. 19.2, Lordship would see page 73. Sorry, Lordship, page 19.2 would be page, Lordship, page 67. I'll just read out 19.641. No student shall be allowed to appear for a
Page number?
67. No student shall be allowed to appear for a particular course more than twice, excluding the first chance, which shall be include the papers which the candidate opts not to appear within the maximum time allowed. Now we are within that. Now, what is a chance? When it will be considered a chance? 19.2, Lordship. A student who duly fills in the end semester examination application form but remains absent wholly or partly in any course will be placed at I grade, and he shall be deemed to have lost one chance. Therefore, for a chance to be lost, we need to fill up the form. We in 2019, 20 for COVID examinations were not held. 19, we did not fill up the form, Lordship. So we did not avail our chance. We availed it on 2021. That is within the regulation, Lord. And in fact, Lordship, the regulation 5.3 allows 5 years to complete. We are within 5 years. We have joined in 2017.
Regulation 5?
5.3. Regulation 5. Regulation 5 covers it. Yeah. Lordship would find that at page number 54. 54.
3 chances.
3 chances and 54, Lordship. The UG degree program for regular students shall be minimum of 3 years and maximum of 5 years. Page 54 and 5.3, Lordship would see no student shall be allowed to appear in any course more than 3 chances. including the regular chance within 5 years. Therefore, it is an admitted case that it is our third chance, which they also do not deny. It is also admitted case that we are within 5 years. And 19.2 says what constitute a chance. In 2019, we have not filled up the form. For COVID, I think 2020
So,
exam.
as per order of this court, you have appeared in the examination.
Yes, Lordship.
Now there remains to be this
Or results
result to
only.
be declared.
Results to be declared. Therefore, Lordship will equitably considered so that we are within the rules. And that case which was decided by the division bench, there the students appeared for the fourth time. So we did not is not covered by the regulation. So we challenged the regulation. There an interesting point appeared that the rule 19 would come only at the time of appearing the examination, and not during examination, after examination is appeared. Therefore, the division bench choose not to decide the claim of the petitioners there and relegated it to a single bench, only upheld the rule. Lordship, I will give the judgment. This is the judgment. Lordship, the facts is different from this case. There it was fourth chance. This we are covered by the rules. An academic and examination council has the power as per 72. And Lordship, therefore, Lordship, my humble submission is that we are within the regulation. They have erroneously initially barred us from appearing, which the High Court had allowed as an interim order. And we have given the examination. We are within the rules, which is admitted case that we have. We are third. This is our third attempt, and we are within 5 years.
So, Mr. Day, there is no dispute about his submission that they are within 5 years, and they have this is their third chance.
Third chance, but my lord, your lordship kindly see, my lord. First, my lord, I shall place 19.6. Page 67. No student shall be, page 67. No student shall be allowed to appear for a particular course more than twice, excluding first appearance, which shall include the papers which the candidate ought not to appear within the maximum time allowed. My lord, they get 3 chances, including the regular chance. My lord, they appeared in 2017 regular chance, then 1 chance in 2018. Then lordship kindly see.
Next chance. One is in 2017
and 2018.
2 chances.
And 1 chance remains.
Yes.
For that, I am coming, my lord. My lord, lordship kindly see 19.2 on the same page. A student who duly fills in the end semester examination application form but remains absent wholly or partially in any course will be placed in I grade, and he shall be deemed to have lost 1 chance. My lord, if they remain absent, the chances are lost.
No, whether
Then, my lord, in 2019, there is no pleadings that they have not applied for 2019. There is no such pleading. There is no such pleading that 2019 they have not applied. Then, my lord, lordship kindly see 19.5.
no, Mr. Day, if they have applied, you produce the documents,
My
produce the forms.
No, they have not applied. They say they have not applied. My lord, firstly, their pleading has to be there, my lord. Otherwise, how could we? No pleadings. There is no statement in the writ petition that they have not applied. And whatever may, my lord, the absent is absent. Whether they applied or not, it does not matter. They remain if they remain absent, then they lost the chance.
Is it?
My lord, it has been said, my lord, remains absent wholly or partially in any course will be placed in absent word is there, my lord.
No,
It is-
if
it-
they
it is- it-
duly fill up the forms.
My
No, the question is whether they have filled up the forms or not.
It is
Well, they have to say, my lord.
the
They have to
statement
say, my
at
lord,
the,
motion.
so this point has come up in the affidavit in opposition. Now I have replied that in my affidavit in reply at page 82.
Page 82.
82.
Let me see. first.
Le-
My lord,
So there is a pleading.
19.5, my lord. Well, then my lord, kindly come to 19.5.
Page number?
82 para 5. Page 82 para 5 of my affidavit in reply.
You finish first, then I should.
Sorry.
You finish.
Sorry, I just clearing it up.
On page 67, man.
Yes.
19.5. All students who are placed in F or I grade in any semester examination shall have to clear the area or backlog papers in corresponding end semester examination. It is not that, my lord, whenever they feel like they can come, my lord, they have to appear in the along with the in the corresponding end semester examination. My lord, corresponding end semester examination, the my lordship kindly come to page page 54, my lord. Page 54, my lord. 5.1. The undergraduate degree program for a regular student shall be for a minimum period of 3 years and a maximum of 5 years from his or her date of admission. Each academic year shall comprise of 2 semesters, odd and even semester. Odd semester, that is semester 1, 3, and 5, shall be from July to December, and even semester 2, 4, and 6 shall be from January to June. There shall be in each semester not less than 19 annual teaching days. So, my lord, this end semester, first semester examination will be is held in the month of December in every year. So they were required to appear in December 2019. They have not appeared. So there is no scope under the regulation to appear in any further time, in future time. Well, there is nothing there in the regulation that they can appear. Otherwise, my lord, the result will be that, my lord, well, this backlog papers, students are few, the separate examination has to be held for them.
No, they have already appeared, person to order of this court.
My lord, your
No,
lordship is director,
yeah.
so my lord, who have allowed them to
Now
appear. And the one, I am told that one technical difficulty is there, my lord. The examination were held in online method. My lord, the service provider, the content period with the service provider has elapsed. My lord, service provider has gone. The data is also not there. That difficulty is
No,
there,
no,
my
no,
lord.
no, you cannot take that plea. As per order of the court, they have appeared in the examination. Now you cannot take that plea. You have to declare their result.
They were appeared by virtue of your lordship's order, my lord. Otherwise, we could not have allowed them to appear as per the regulation.
Heard Mr. P.P. Pora, learned counsel for the petitioner, and Mr. Day for respondent authorities. Argument concluded, order reserved.
Deeply.
For bail hearing item 5.
Lordship, reading is there in para 5 and para 7, page 82 and 83,
You mark
regarding
it
that
in the-
chance.
You mark it in the affidavit.
Yes, yes, para
The
5 and
reply
para-
filed by you.
yes. Deeply obliged.
Marking.
May I please, Lordship, learned counsel Mr. M. A. recently appeared for the petitioner. He is on leg, Lordship. The matter may be taken up after some times.
Taken up?
After some times.
My lord, I will leave
He's
the
on
court,
leg.
my lord, early, my lord. Kindly take my lord, step. And Monday, my
Pardon?
lord. I have to leave, my lord, early.
Lordship, just few minutes. He is on at court number 18, Your Lordship. The matter is going on, Lordship.
So somehow wait for some time.
Well,
Obliged.
item 6.
May I please, Lordship? Lordship, we take a step upon the response number 2,
Pardon?
but serviceable is avoided, Lordship.
Service report awaited.
Lordship.
Wait. Okay, those- এইটো আহিলে না এইটোতো দিব লাগে
Notice issued. 17 March of exposition of office copy. Office copy. Office copy.
Mr. Sharma, you were also appearing in this application 477.
Item number? Item 6. 6, my lord.
Where is the service report?
I have to take instruction, my lord, from office.
When?
But after some time, my lord.
Okay. Next.
Item 7.
Right, please, Your Lordship. My lord, it is a second bail application before your lordship. First one rejected by your lordship. And that rejected order I have annexer D, etc. Order passed by your lordship.
So,
Not
Mr. Sharma,
annexer.
you have received the CD.
My lord.
Yes.
My lord, FIR speaks that the money demanded, my lord. FIR I have annexed at page 16 to 20. Right? 16 to 20 is the annexer A. Annexer speaks that money demanded. But money, whatever the amount, my lord, that not delivered. When money not delivered to any person, accused person, my lord, it is not extortion. And this is an observation given by the learned CGM while granting the payment to the some accused persons
No, Mr. Hazarika, you see, after perusing the case diary, we have rejected the earlier petition.
That is
Now,
true.
what is the new ground for filing this present application?
Grounds we have taken, we have annexed the order passed by the learned CGM, my lord. CGM also perused the CD. my lord.
Then which order will prevail? The order passed
That
by
is
this court
order
or
passed
by
by
the?
your lordship is superior, my lord, no doubt
Then-
at all. But question is, my lord, extortion, offense
No,
of
you
extortion.
you cannot submit on merit now.
Now, question is, my lord, CD, if your lordship will re-examine, no material has been recovered from the accused persons, my lord. Not another single.
No, is there any requirement of recovery from the accused persons?
Nothing recovered, no incriminating articles recovered, money not recovered because it is not delivered to the persons, my lord, accused of. There are four accused persons. None of the accused persons money not. It is also informant says that money not given to them, though demanded. So the ingredients of section 308 is not attract, my lord, in the case.
No.
That is
whether-
not
whether-
honestly reflected
No,
by the learned
Mr.
people before your
Hazarika, you
lordship.
see whether at this stage we will discuss the ingredients of the offense. Or we will see the prima facie material.
Yes, my lord, that is I have seen, my lord. I have gone through the order passed by your lordship.
Mm.
But question is, my lord, whether ingredients of the extortion is attract in the present case or not, my lord. That is also important, my lord. That is why the second bill
No,
application filed before your
whether
lordship.
in
FIR
dealing with a anticipatory bail application, we are supposed to discuss
Apprehension.
all those materials. Because the investigation is still going on. Yes, what is the stage of investigation?
My lord, thereafter, my lord, some apprehended person, my lord, police is after them, my lord. My lord, from the, my lord, rejection date, my lord, there is just one that is, my lord. Only house search is there. House search, my lord, Lukriti Nath was search, my lord, was apprehended, my lord. Lukriti Nath, my lord, the present petitioner, my lord. His house was searched, my lord, but he was not found, my lord. That a rejection of your rejection of by your lordship, my lord.
No, it was stable. Because his father was a heart patient. He is receiving treatment in outside the state of Assam. So he is attending his father when police came to the house.
Well, where is the
That-
document?
Documents I have not annexed. It required, my lord,
Then-
that it is a statement I have made in support of my affidavit, my lord.
Oh, your statement will not do unless you furnish.
Supported by affidavit, my lord. Supported by affidavit.
Pardon?
Affidavit I have annexed.
Maybe.
My affidavit,
Maybe.
it is true. That is why I have given my affidavit to support the statement which I have made, my lord.
So basically, you are harping on two grounds. One is the ingredients are not detected here, and the other is your father is undergoing treatment.
yes.
That is the ground.
Yes, my lord.
But you have no medical document to support that your
If
father
required, I
is
will file additional affidavit.
undergoing treatment. Okay. Mr. Sharma, you what is the case that we'll pass the order, we'll see.
Number 9, matter for orders.
May I please, Your Honor? Honor, in this IA, they have seek time to file objection from last 2 days. Today also they have informed that they have not filed the objection. But
No, are they present?
they've informed me at morning that they will seek time again. But I'll take 2 minutes time of the Honorable Court to narrate my urgency in this case, Lordship.
Urgency without hearing the other side, can we pass any order?
No, not any order. And it may be.
Wait for some time. In the meantime, he may come.
Obliged.
Thanks.
Item 10 for hearing.
Item number 9, sheet.
Lordship, I am appearing on behalf of respondent number 4 and 5. Lordship, the matter may be fixed after a week. We will file our affidavit.
No, the counsel for the applicant submits that he has some urgency.
Lordship, but
Lordship, there is a grave urgency. I will take 1 minute time of the Honorable Court to narrate my fact.
Our affidavit is ready, Lordship. Lordship may have the matter next week, Lordship. Next week.
No. The counsel for the applicant submits that he has some urgency.
Yes, Lordship. Lordship, I know that, Lordship, they may have the matter on next week, Lordship. In the meantime, we will file our objection, Lordship.
Monday then?
Monday? Oh.
Lordship, on 8th, Lordship.
8th, Tuesday. Tuesday.
Not Tuesday. Tuesday is hearing then.
Wednesday.
Wednesday, Lordship. Next week, any day, Lordship.
Wednesday, 9th.
In the meantime, we will file our affidavit on Monday, Lordship.
On the pair being made by Mr.
K. Kolita, Lordship.
K. Kolita, learned counsel for the respondent, opposite party. Recessal is the matter on.
I am for 4 and 5, Lordship.
4 and 5 on. 9. Mr. Yogur.
S. Nag. S. Nag.
S. Nag, learned counsel for the applicant present. List recording.
Timing item 5.
Obliged.
May I please, Your Lordship? Scan copy of LCR is called for, my lord. In this case, I was behind bar for 55 days, my lord. FIR is at page number 12. The long FIR, my lord. And allegations contain section 111, 61.
So you are behind the bar.
Yes, my lord. And
you have surrendered as per order of this court.
Yes, my lord.
When?
I have surrendered on, my lord, 8th of February, my lord.
8 February.
Yes, my lord. After 2 days from the direction, my lord. And thereafter, my lord, for 1 day I was and now, my lord, I am in judicial custody, my lord. I am not the FIR named accused, my lord. Perhaps later on, my lord. Actually, I am a laborer working in, my lord, Stone Quarry, my lord.
What is the earlier order?
Earlier order is at page number, my lord, 19.
Page number?
19. That is anticipatory bail order, my lord, and direction is at page number 20 and 21, paragraph 7, my lord.
after some time, additional PP absent.
At 2 PM, my lord.
2 PM. Okay.
My lord.
For hearing item number 10.
May I place your lordship? Lordship, on last occasion, I proposed two more additional substantial question of law, lordship. And your lordship told me that my the substantial question of law which has already been formulated by the honorable court, whether the learned courts below committed error in declaring title of the defendant number 6 and 7 over the whole plot of land covers the additional substantial question of law which I have proposed, lordship, on last occasion. I do agree, lordship. Impliedly, the substantial question of law number 1, which has already been formulated, impliedly covers my proposed substantial question of law number 3, lordship. However, lordship, regarding additional substantial question of law, which I have proposed as number 4, that may be formulated, lordship. As because, lordship, if your lordship kindly goes through page number 11 of the appeal memo, lordship. I think in the suit I was, we were the plaintiff, lordship. The learned senior counsel is appearing on behalf of the defendant number 6 and 7, who had filed a counterclaim against us. Lordship, at page number 11, it is a prior portion of our plaint, lordship, plaint of the plaintiffs, lordship.
No,
Here we have.
You first come to additional substantial question of law. Whether there is any necessity of having the same or not. Yes, Mr. Dekka, you have gone through the suggested substantial.
No necessary, my lord. There is no necessity to formulate again, my lord. Already it is covered, my lord.
Covered.
Yes, my lord. Because, my lord, the main case is regarding the adverse position. So that issue was framed, my lord, rightly framed, my lord, and it is decided. So in a suit, my lord, for adverse position, main question is regarding possession, my lord, whether more than 12 years, adversely, continuously, and openly, my lord, with the intention to possess. So that is formulated, my lord. It is a issue of
Judgment of the trial court?
Trial court, my lord.
Lordship, we prayed for declaration of right title interest in the plain.
My lord,
Let him complete.
Okay, Lord.
adverse position, my lord. He claimed adverse position. So when position is not there, my lord, then how can declaration of right title interest, my lord? His right title interest on the basis of position, my lord. On the basis of position for long 12 years, adversely, my lord. So issue was framed, my lord.
Number 3.
Yes, my lord.
So number 3.
Yes, whether
Issues
plaintiff
are
has
at
been-
page 39, lordship.
Yeah.
Page 39, my lord, whether plaintiff has been possessing the suit land for more than 12 years against the interest of the defendant. So this is the main issue regarding his claim, my lord. If he has possession for more than 12 years, then automatically he will get declaration, my lord, under article 65 or 64, whatever may be that. So, my lord, when possession, that particular issue is there, my lord. And to that effect, evidence was adduced, my lord, both parties. So that was negated by the trial court, my lord, as well as the first appellate court, my lord. So how can be declaration for right title interest without possession, my lord? That cannot be, my lord. And even though, my lord, even if your lordship decided this case on the basis of the substantial question of law, then also in any issue, my lord, record to be issued by but your lordship can decide, my lord. Here itself, my lord. So no framing of new substantial question is necessary, my lord. Because apart from the substantial question, any other question that can be decided by the by the court as a second appeal, my lord, are 100 subsequent 3, my lord. In deciding substantial question of law, my lord, where involved a substantial question of law, your lordship can decide other issue also, even if it is not substantial question of law. So, my lord, in the trial and hearing, my lord, if he thinks fit that there is necessity for decide any issue, then your lordship
Then
can,
we
my lord.
can.
Yes, my lord.
Okay.
So, there is no necessity for
At this stage.
at this stage, my lord. The hearing after 15 years, my lord. So, on the basis of these two substantial question, matter may be decided, my lord. It is concurrent finding.
Okay, you start argument.
Lordship, my humble submission is that it is admitted fact by the defendant and as well as counterclaimant also that we are in possession. It is admitted fact, Lordship. And we have specifically prayed for declaration of right title interest over the Schedule B land, suit land, Lordship. And in the prayer portion, I have stated, Lordship, in the prayer portion, we have specifically, Lordship, I am reiterating, Lordship, at page 11, Lordship. Now, the first prayer is, our first prayer is, right title and interest of plaintiffs over the suit land more fully described on Schedule B to the plain bio of adverse position. That has been opposed by the defendant, Lordship. And that's why framing of issue with respect to declaration of right title interest of the plaintiff is a important issue, Lordship. And if your Lordship kindly goes to page number 39, where the issues are stated, Lordship, here is no issue was framed regarding declaration of right title interest of the plaintiff, Lordship. Only declaration of right title interest of the defendant was an issue with respect to the declaration of right title interest of the counterclaimant is framed, Lordship, whereas they have not prayed for declaration of right title interest in their counterclaim, Lordship. On the other hand, Lordship, we had prayed for declaration of right title interest of the plaintiffs over the suit land. But with respect to that fact, no issue was framed by the trial court,
Maybe,
Lordship.
but whether the trial court has discussed anything about the right title and interest of the plaintiffs while dealing with that issue?
Nothing,
Issue number
Lordship.
4?
Neither by the trial court nor by the first appellate court discussed with respect to our declaration of right title interest.
So let us see the issue number 4.
Lordship, your Lordship, if your Lordship kindly goes to the page number 21 of the appeal memo. This is the prayer from the bottom part, Lordship. The prayer portion of the counterclaimant has been started, Lordship. On page 22, at page 21, Lordship, their first prayer is the decree may be passed for eviction of the plaintiff from the scheduled land with respect to eviction, Lordship. Prayer number B is that a decree be passed to put the defendant number 6 and 7 in position after recovery of scheduled land and removing all the obstruction of the plaintiff from there. The permanent injunction may also be issued against the plaintiffs, their employees, etc. for making any obstruction, nuisance in respect of peaceful possession of the land stated in the schedule. That the cost of counterclaim may also be decreed. Any other relief, Lordship. No prayer for declaration of right title interest of the counterclaimant over the scheduled land was prayed for by the counterclaimant, Lordship. But even though issue was framed, Lordship, even though issue was framed and issue was decided in favor of the Lordship counterclaimant. Lordship, the provision of CPC does not say that the issue can be framed if it is absent in the pleading, Lordship. Even though issue was framed, but on the other hand, though we pray for declaration of right title interest, no issue was framed, Lordship.
No, let us see the issue number 4. How the trial court has dealt with the same.
Yes, Lordship. Lordship, at page 45, the trial court discussed the issue number 4, Lordship, whether the defendant has right title interest over the suit land averred in the counterclaim. The defendants have stated that defendant number 1 to 5, that is legal heirs of late Farad Bhagavati, are the owner of 3 kothas of land of both the suit pattas. Defendant number 1, Sri Midul Bhagavati, sold 3 kothas of land to defendant number 6 and 7 by executing a registered sale deed and also delivered possession of the entire 3 kothas of land, including Schedule B land of the plain, also in presence of village and both the plaintiffs. Lordship, here I beg to state, though they have stated in the counsel, the counterclaimant has stated that they have taken the position, but it is thereafter they have admitted that they are not in position, and we are still in position from the very beginning, Lordship. On the date of delivery of possession of the land, that is on 12/2/2011, and that day, also both the plaintiffs submissively and open declared in presence of those villagers that as soon as possibly they would vacate the Schedule B land to the defendant. And accordingly, after being satisfied with the report of Lat Mandal of village Kaljar, Circle Officer Borama mutated the name of the defendant number 6 and 7 in the SITA by virtue of purchase in place of defendant number 1 at both the suit patta on the day of 23rd February 2011 and 24/2/2011, and which was corrected in the Sadar Jamabandi also on 28/2/2011. Accordingly, the right, title, and interest of a schedule land of the plain acquired by the defendant number 6 and 7. Learned advocate for the plaintiff has submitted that the defendants admitted in their written statement that the suit land is joint family property. The defendant number 1, here is another fact, Lordship, the property was a joint property, and defendant, the property belonged to defendant number 1 to 5 jointly. It is also admitted by the defendant number 1 to 5. But defendant number 1 solely sold the property to the defendant number 6 and 7. It is another aspect, Lordship, that has not been, Lordship, proposed for substantial question of law, Lordship. Defendant number 1 alone sold the suit land to another person. He has no right to sell the suit land alone. There is no evidence regarding partition of the joint property. No notice issued to the defendant for evicting the shop house. The suit land was sold without handing over actual physical possession. Sale without delivery of possession is not valid sale. Though defendants know that the plaintiffs are in possession of the suit land at the time of sale of the suit land, but the defendants have also not taken step for eviction of the plaintiffs from the suit land, despite knowing that the plaintiffs are occupying the suit land. Though the suit land is in possession of the plaintiff, but in the sale deed executed by the defendant number 1, it has been stated that physical possession of the suit land was handed over to the purchaser. On other hand, learned advocate for the defendant had submitted that defendant number 1 has saleable right as per record of rights. Even if there is any dispute with regard to right of defendant number 1 to sell the suit land, his brother and sister will hesitate the same. Other persons have no locus standi to raise any dispute with regard to saleable right of the defendant number 1. The plaintiffs have exhibited the certified copy of sale deed as Exhibit 4. The defendant side has exhibited Exhibit Q, the certified copy of the Jamabandi of suit patta 322. The name of defendant number 6 and 7 are mutated in the suit patta by virtue of purchase in place of defendant number 1. After the date of Sharad Bhagavati, name of defendant number Sharad Bhagavati is the predecessor of defendant number 1 to 5, Lordship. After the death of Sharat Bhagavati, name of defendant number 1 was mutated in the suit patta in place of his father. Exhibit Go is the certified copy of sale deed. It is not in dispute that late Sharat Bhagavati was the original owner of the suit land. After his death, the suit land devolved upon the legal heirs of late Sharat Bhagavati. The defendant number 1, being the legal heir of late Sharat Bhagavati, sold the suit land to the defendant number 6 and 7. Lordship, defendant number, it has been observed by the learned trial court that defendant number 1 alone sold the suit land to the defendant number 6 and 7. In such circumstances, none other than the legal heirs of late Sharat Bhagavati can question the right of defendant number 1 to sell the suit land. Other legal heirs of Sharat Bhagavati have not disputed the sale of the suit land by defendant number 1. On the contrary, all other legal heirs of late Sharat Bhagavati stated that defendant number 1 sold the suit land to the defendant number 6 and 7. Both the defendant number 6 and 7 are bona fide purchaser of the suit land. Thus, there is no dispute among the legal heir of late Sharat Bhagavati about the power of defendant number 1 to sell the suit land. The name of defendant number 1 is also mutated in respect of the suit patta in place of his father. And none of the other legal heirs of late Sharat Bhagavati objected to such mutation of name of the defendant number 1. This has only, Lordship, these statements are only submitted by the counsel for the counterclaimant during the argument, Lordship. No document was produced by them at the stage of filing written statement or at the time of adducing evidence, Lordship. Moreover, the defendant number 1 deposed that he handed over possession of the land to the defendant number 6 and 7 after sale of the land, Lordship. Here they have taken two contradictory statement. Once they stated that they are in physical possession of the suit land was delivered to the plaintiffs. On the other hand, they are praying for recovery of possession, Lordship. The delivery of possession may be actual and constructive. The provision enunciated in section 54 of Transfer of Property Act made it clear that sale of tangible immovable property of the value of more than 100 rupees can be made only by a registered instrument. Thus, the legal requirement for sale of tangible immovable property of the value of more than 100 rupees is execution of a registered sale deed only. In such a case, registered document need not be accompanied by delivery of possession. Hence, the sale deed executed by the defendant number 1 is a valid sale deed, and as such, the defendant number 6 and 7 acquire right, title, and interest over the suit land on the strength of the sale deed. Here, the discussion on the issue number 4 is closed, Lordship.
But it appears that though no issue was framed on that point, the trial court has discussed the matter there to some extent.
To some extent, Lordship.
Will it continue at 2 p.m.?
Respondent, my lord, but I am been told now, my lord, that the counsel for the appellant has not yet come, my lord, from Delhi. So may I?
Number 14.
My lord, I am for the respondent, my.
So when to be listed?
Lordship kindly fix either 24 or 22 April.
After vacation.
My lord.
Okay. On the pair being made by Mr. Jaya Borgunya,
As informed by
for the respondent, with consent from the addressed press for listing the matter on
Lordship, in the month of May, 1st May.
1st of May.
Tuesday, Thursday.
Thursday.
May it please your lordship. Lordship, I beg to mention item number 18, lordship. Lordship, the arguing counsel for the responding side, Mr. P. Das, his father is expired, lordship. So with the consent.
Item number 18.
Yes.
Yes, Mr.
G. Das, lordship. I am appearing on behalf of P. Das.
Appearing on behalf of Mr.
P. Das, lordship.
P. Das, learned conducting counsel for the respondent. You informed the other side.
Yes, lordship.
With consent from the other side, press for listening the matter when?
Last week of April, lordship.
Second week
Last week of May.
First week of May.
First.
On 8th May.
8th of May.
Much obliged.
Yes.
May I please, my lord? My lord, with the consent of the petitioner side, my lord, I bring for adjournment of item number 13, my lord.
Item number
13, my lord.
13.
13, my lord.
Okay.
Can you give this?
You for respondent.
I'm on behalf of Mr. S.P. Chaudhary for respondent.
Mr. Your good name, please.
K. Vishwakarma, my lord.
K. Vishwakarma, Learned Counsel, appearing on behalf of Mr. S.P. Chaudhary, Learned, conducting counsel for the respondent with consent of the other side as for listing the matter
After vacation, my lord.
after vacation. Fair enough.
On 13th May.
I'm obliged.
Yes.
My lord, may I place the information regarding my lord, item number, my lord, 6, my lord? That regarding notice of service of notice, my lord. Actually, my lord, those that slip, my lord, which was furnished in our office, my lord, instead of my lord Khetri PS, it is mentioned as my lord Sonapur PS. So my lord is sent
By
to.
the petitioner.
No, my lord, by the petitioner, my lord, maybe petitioner or my lord, maybe registry, my lord. So my lord, in the entry, my lord, on dated, my lord, 18/3, my lord, is mentioned as my lord Sonapur PS 190.
Because of whose fault?
My lord,
The applicant or the office?
My lord, mistake maybe here, maybe in our office also, my lord, I cannot say. This is not inadvertently, my lord, the mistake was there.
If it is the mistake on the part of the council, then we have to ask him to furnish the press. This
We have to, my lord, furnish press because, my lord, it has to go to the Khetri PS, my lord. It invariably, my lord, goes to the.
Okay. Take down. Mr. Sharma, learned additional PP submits that service report has not yet been received due to mistake. Maybe on the part of the applicant or on the part of the office. And he submits that necessary direction may be issued to the applicant to take press step up of the respondent number 2. Accordingly, it is provided that learned counsel for the applicant shall take press step up of respondent number 2 within 2 working days. You have taken step up on the respondent number 2.
Yes, sir.
You have mentioned the police station as Khetri or as Sonapur.
Sonapur.
Sonapur. But the cases of Khetri PS. You take press step upon respondent number 2. Within 2 working days from today. List the matter after.
Also date 30 April. 30.
In the meantime, you have received the case diary. No.
My lord, case diary received, my lord.
Okay. Till then, case diary shall be retained.
Item 10 to continue.
Yes.
Lordship, before placing my further argument, Lordship, Lordship, with due respect, I beg to submit, Lordship. I suppose that today's submission will be limited to the issue whether new additional substantial question of law is to be framed or not, Lordship. I'm actually not ready for final hearing, Lordship.
You were not ready for final hearing. Yes, Mr. Dekam.
To that effect, no order. It is fixed for hearing. If some difficulties may not.
As per Lordship, last order passed by this honorable court, I suppose like that, Lordship. So.
Okay. On the prayer being made by Mr. Sharma, learned counsel for the appellant. having not been objected by Mr. Dekka, Bernardino, counsel for the respondent, assisted by Madam So-and-so. Recessal is the matter for hearing as partnered on 15th of May.
Lordship. Highly object.
Timing item 5.
My lord, is there pardon, my lord?
Pardon.
Yes.
Pleasure, Lordship.
Yes.
Scan copy of the LCR is called for, my lord, and
LCR received.
yes, my lord.
So at what is the case is pending now?
Production only, my lord.
Production.
Charge sheet, my lord, file on, my lord, 9 and 9-3, my lord.
Search it file on 9-3.
9-3, my lord.
And my lord, as per direction of this honorable court, I appeared before the police, my lord. And on appearance, my lord, I was arrested and thereafter forwarded, my lord. I am cooperating during the investigation, my lord.
So what is the punishment prescribed under section 111 of BNS?
No, the 111. Charge sheet, Charge sheet. 5 years, my lord.
5 years.
Yes, my lord.
And 61 within bracket subsection 2.
It is shown, my lord, one is life, if it is serious nature in, then my lord, life imprisonment and other
No,
four
what is the offense?
offenses, my lord. Yes, 61, 61 proposal.
Sixty-one is conspiracy.
Conspiracy, my lord. Conspiracy, my lord. Criminal conspiracy, my lord.
And 288?
Wait. It is 6 months and fine. No? Explosive substance, my lord, industrial negligence as to endanger human life. Or will likely to cause hurt or injury to any other persons or knowingly or negligently omit to take such order with any explosive substance in his possession as is sufficient to guard against any probable danger to human life from that substance shall be punished with imprisonment from which extent to 6 months or with fine, my lord. Possession of explosive substance, my lord.
And regarding 4 and 5 of explosive substance act.
It is for life imprisonment and 10 years, my lord.
4, section 4.
Section 4, life imprisonment. If it is in serious nature, my lord, then life imprisonment. Otherwise, it is 10 years, my lord. And section 5 also prescribed 10 years imprisonment. 4 and 5.
Five also 10 years.
My lord, punishment for attempt to cause explosion, my lord. Or making or keeping explosive with intent to endanger life and property. But I am not the FIR named accused, my lord.
Okay, that, explosive substance act.
Okay.
So no FSL report received here.
Receive, my lord.
And what is
That is there, my lord. I have like mark.
What are the special category explosive substance? The substance, explosive substance seized from his position is ammonium nitrate.
My possession, my lord, nothing has been seized, my lord. I'm not the FIR named accused. The substance are stored in the house of one Rukia Khatun by one Izazul Mia, my lord. I'm not the FIR named accused, my lord. From my position, nothing has been seized, my lord. Later on, police searching me, therefore I approach before this honorable court And this honorable court, while rejected my bail petition, directed to me to
No,
appeal.
no, there is evidence to show that
Yes.
those materials were kept by you in the house of that lady.
But the FIR says other thing, my lord.
After
That's why I'm
investigation.
going on by the FIR, my lord. I'm submitting on the FIR only. What is in investigation, I don't know, my lord. But so far the FIR is concerned. my
No,
lord,
you have been furnished with the copies of the statement.
uh, as an advocate, till I don't have the copy, my lord, but whether it is furnished to him or not, my lord, that is not known to me, my. So I have the FIR. On the basis of FIR, I am submitting, my lord.
Pardon me, sir.
M.A. Hussain.
Learned counsel for the accused and also heard Mr. Sharma, learned for the respondent. This application under section 483 of the BNS S is preferred by accused Anwar Hussain alias Anwar Islam, who has been languishing in Jailazut in connection with Mankasar PS case number 221 of 2024 under section 111 stroke 61 Mega 2 stroke 288 of the BNS, read with section 4 and 5 of Explosive Substance Act 1908 for grant of bail. Mr. Hussain, learned counsel for the accused, submits that this is the second bail application prepared by the accused, and the first one, being AB number 146 of 2025, was dismissed by this court by order dated 6/2/2025. Mr. Hussain further submits that person to order passed by this court on 6/2/2025 in the AB number 146 of 2025, the accused herein surrendered before the IO, and thereafter he was remanded to judicial custody, and he is languishing in Jailazut for more than how many days he is behind the bar?
As on today, 55 days, my lord.
For plus 55 days, and that in the meantime the investigation of the case is completed and search sheet has been laid before the learned trial court, and that the accused will appear before the learned trial court on each and every date, and therefore it is contended to allow this application. Yes, Mr. Sharma, what is your submission?
My lord, this stage, my lord, because trial is in very initial stage, my lord, that may not be considered, my lord.
It's paragraph number 3, page number 20. On the other hand, Mr. D. Sharma, learned additional PP, has opposed the petition on the ground that the case is in the initial stage. Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the scanned copy of the record received from the learned trial court. It appears that the accused herein has preferred one pre-arrest bail application being AB 146 of 2025, and the same was dismissed by this court after perusing the case diary on 6/2/2025 with a direction to the applicant therein to surrender before the IO. And further, it appears that accordingly the accused surrendered before the IO on 8 June 2025, and since then he has been languishing in jail as for the last 55 days. Further, it appears that investigation of the case has already been completed and charge sheet has been laid before the learned trial court on 11/3/2025. 11/3/2025, and it appears that the accused has been charge sheeted under section Further, from the materials collected in the case diary and also from the charge sheet, it appears that the accused is a daily wage earner and he used to collect the explosive substances from Meghalaya and sold the same in higher price. And since the investigation of the case has already been completed and charge sheet has been laid before the learned trial court, and since he has been languishing in jail for the last 55 days, this court is of the view that further custodial detention may not be warranted. May not be warranted in the interest of investigation, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned trial court, the accused shall be enlarged on bail. The learned trial court will be at liberty to impose any condition so as to ensure attendance of the applicant accused during trial.
Item number 20 fixed at 2 p.m.
Your Lordship, on the last date, we were directed to file an additional affidavit to bring the charge sheet on record, Your Lordship.
You have filed your affidavit.
Yes, Your Lordship.
When?
It's there in the record, Your Lordship, IA 419. Additional affidavit to bring on record the charge sheet.
So what was the ground for issuing such a direction?
Your Lordship, this charge sheet was not available in the LCR also. And none of the other side advocates had a hold of it, and we had a certified copy of the same. So your Lordship directed us to file this so that it shall be available with everyone, and then we can proceed with the disposal of the case, Your Lordship. Because Your Lordship, in the last 3 dates, it was fixed for orders, but on the last date, Your Lordship said that as soon as the charge sheet is filed, the matter can be heard and disposed.
So this IA was for allowing to withdraw the 50%
Yes, Your
of
Lordship,
the
the
award.
claimants, the respondent, they filed the IA for withdrawal. We filed our objection to it. I am appearing on behalf of the appellant. And when this IA was taken up, your lordship wanted to hear the matter. And since we were relying on the charge sheet as well, and the charge sheet was not available in the LCR, so we were directed to file an additional affidavit to bring the same on record.
Mr. Goswami, you work for National Insurance Company.
Yes, Lordship.
So who deposited the 50% amount?
Your lordship, we have deposited, but we are objecting to its withdrawal, your lordship.
Why?
Your lordship, because the main point of our appeal is that we are not even liable for the accident, and which we can prove before the honorable court. And so if we are not even liable, then withdrawal at this stage would render the appeal infructuous, your lordship. If your lordship may permit, I can show before this court, honorable court, that we are not even liable for the accident, and it was only the other vehicle, since there were two vehicles involved in this accident.
One is truck and other is Magic.
Tata Magic, yes, your lordship. The deceased, he was in the Tata Magic vehicle, and he was hit, this Tata Magic vehicle was hit by another vehicle truck from the back side. And it has been stated in all the evidence everywhere that even in the claim petition, your lordship, that the accident took place due to rash and negligent driving of the driver of the truck who knocked the Tata Magic from the backside, as a result of which the deceased succumbed to his injuries on spot. But the learned tribunal erroneously held both the insurance company of Tata Magic as well as that of the truck, to be equally liable. So, lordship, the National Insurance Company, they've already deposited, which has been withdrawn by the claimants. But we are objecting to its withdrawal because we are not even liable at this stage, your lordship.
So search sheet is submitted against the driver of the truck.
In the
Both the way.
if your lordship may see the charge sheet, page page 24 of the additional affidavit, your lordship, the typed copy. Your lordship, in this, may I read, your lordship? Page 24.
No, yes, last part, after investigation, search sheet was filed against the driver of offending vehicle bearing registration number.
Yes, your lordship, against the driver. Yes, your lordship.
Truck, namely Ghara Singh, and the driver of Magic bearing registration number AS17 B-0350, namely Abdul Alim Sheikh. So against both the driver,
Yes, your
it
lordship.
was submitted.
But your lordship, this charge sheet, in the first part of the charge sheet, your lordship may come to this part, 4-5 lines below, that
Madam, this is not a criminal trial.
your lordship, apart from this charge, firstly, your lordship, this charge sheet was filed.
Who is for the applicant of this IA? So you have already withdrawn some of the amount.
By the insurance company of the truck, they have deposited and they have stored.
Okay, since a search sheet has been submitted against the driver of both the vehicle, prima facie case is there. Let them withdraw the amount, we will hear the appeal finally.
Your lordship, it was also observed by honorable court that the IA and the hearing can be taken up together, because if it is withdrawn, your lordship, it becomes, there's no point of taking it back. And if you're not even
Whether
liable.
the appeal is ready for hearing.
Yes, your lordship, it may be taken up even on the last date. Your lordship wanted to hear the matter, but since the charge sheet was not available, it could not be taken. If your lordship permits, it may be taken up now. Because your lordship, the charge sheet only on basis of one document charge sheet, which was filed after 6 years of the accident. we cannot be held liable. I have evidence to show that we are not liable, your lordship. If the claimants withdraw at this stage, your lordship, the appeal becomes infructuous.
How? How?
Your lordship, if it is taken at the hearing
No,
stage,
they will punish on bond.
but your lordship, if your lordship permits, if it can be taken up today, the matter can be
No,
heard.
whether the parties are ready for hearing, that is the question. Yes, madam, are you ready for hearing today? Mr. Goswami?
It can be hard. Look. It can be hard. It's not ready, but
It can be heard.
it can be hard.
Okay.
Mademoiselle, the copy of the charge sheet, I probably found it in the records also, along with a trace map, but I could not decipher the trace map. So, I don't know, I could not make anything out of it. It's not legible.
Pardon?
That trace map.
Sketch map.
Sketch map. Sketch map is not very clear. And charge sheet is based on the sketch.
No, search it cannot be based on the sketch map.
It
Search
speaks
it
about
is
it,
only based upon the evidence adduced by the
Yes,
witnesses.
but also had taken that into consideration. I read it somewhere, that's it. Where is it? The charge sheet is there. It was not objected to.
And sketch map is also hit by section 162 of the CRPC. Because it is prepared on the basis of statement made by the witnesses. So you tell me, are you ready to argue the matter, or we will pass a dispose of this I?
Yes, I can be disposed of if finally, lordship, it turns out that one company is only liable, then the direction can be given for you.
Your lordship may also fix a date for taking up the hearing, and on that day, if
No,
you're
no,
liable,
yes, we will dispose of the I today.
your lordship, the matter can also be heard then if the other sides are.
Let them withdraw the amount. They will execute a bond.
It is lordship, the dispute is between both the insurance company. For that, claimant should not have lordship. The accident is proved, lordship, the liability is also proved. They are not denying that there is no liability. The claimant is not entitled, it is not denied. Only their part, their liability part is there denied. From that insurance company or this insurance company? claim
Or
is
this,
entitled.
or so today learned counsel for the applicant. And madam, your good name, please.
A. Biani.
A. Biani, learned counsel for the respondent opposite party number. Respondent opposite party number 1 and Mr. Goswami for respondent opposite party number 2. This interlocutory application is prepared by the applicant. Under section 151 of the Code of Civil Procedure for allowing to withdraw 50% of the awarded amount deposited before the registry of this court. Ms. Sodore, learned counsel for the applicant, submits that when the amount was deposited,
Your lordship, on 27th June 2024.
3779. In that file, there was an order.
Okay. Okay. Person to order of this court dated 27/5/2024 passed in I number 3779 of 2017. The respondent opposite parties number 1 and 2 have deposited 50% of the awarded amount before the registry of this court, and the same may be allowed to be withdrawn by the applicant hearing. On the other hand, Ms. Vianney, learned counsel for the respondent opposite party number 1 has vehemently opposed the petition on the ground that after 6 years of investigation, the police has submitted charge sheet against the driver of both the offending vehicle, and in fact, Tata Magic vehicle which was insured with the opposite party number 1 is not at all involved in the accident. And if the amount is released in favor of the applicant, that is this, then the appeal become success. Mr. Goswami submits that, learned counsel for the respondent number 2 submits that. Respondent opposite party number 2 submits that the respondent opposite party number 2 has already deposited 50% of the awarded amount, and the same has already been withdrawn by the applicant. Taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to allow this application. The applicant is allowed to withdraw the amount of 50% deposited before the registry of this court on executing a bond of equal amount. In view of above, this IA stands closed. The recessal is the MSC appeal for hearing on. Mr. Goswami suggested that.
Any date, Lordship. Any date, maybe. Immediately after the hearing.
I think in this case, indemnity bond will not be required as because I am entitled for the money either from that insurance company or from this.
You execute one bond.
Much obliged.
Item number 11.
May it please your lordship. So the appeal is referred by the insurance company challenging the liability. Our ground on challenging the liability is that at the time of the accident, the policy was not there, your lordship. The policy had already expired. Accident occurred on 30/9/2013, your lordship. And the policy expired on 19/6/2013. If your lordship may kindly take up the LCR.
What is the ground for filing this appeal?
Appeal also we are challenging the liability, your lordship.
Why?
At the time of the incident, the policy had already expired, your lordship.
Policy already expired.
Lordship.
Whether you have taken such a plea before the tribunal?
Yes, your lordship. And even the record shows that.
Whether any issue was framed on that count?
On that count, your lordship, issue was not framed. However, there is a discussion in the judgment. Because
in the issue number, in which issue it was?
issue number 2, lordship.
Yes.
Paragraph number 6. While opposite number 1 did not cross-examine the claimant, the opposite party number 2 has taken the plea that the policy of insurance was not valid on the date of his accident. In support of its plea, the contesting opposite party has adduced evidence of one defense witness. During cross-examination, he has admitted that he was not given formal letter authorizing to depose on behalf of the company of the insurer. The defense witness number 1 has exhibited the policy details, right? Exhibit A,
which shows that the certificate number given in the policy is the same as policy number given in the accident information report exhibited by the claimant. In cross-examination, he has admitted that certificate number and policy number of an insurance policy are different numbers. In view of this admission, it is not possible to accept that the Exhibit A is in respect of the policy number mentioned in accident information report. As such, plea of the insurer that the policy of insurance was not valid on the date of the accident is legally not sustainable. Only because of a statement given during the cross-examination, our evidence was discarded, Your Lordship. However, the record shows clearly that the policy had expired at the time of the accident, Your Lordship. If Your Lordship may kindly take up the LCR, page number 22 of the LCR, Your Lordship.
So this policy number and
certificate
number are same.
Same, Your Lordship. Policy number is the certificate number. And from at the time of the filing of the claim, the policy number mentioned in the LCR, Your Lordship. If Your Lordship may kindly take up the memo of appeal, claim petition, Your Lordship, filed by the claimant.
Yes.
The policy number, Your Lordship, in the array of parties, number 2, regional manager, National Insurance Company Limited. Here, the policy number is written, Your Lordship. 351007311 26200705817. This is the policy number, Your Lordship. And it is also the certificate number. The policy number and the certificate number are the same, Your Lordship. Now, Your Lordship may kindly come to page number 22 of the LCR. That is the Form 54, Accident Information Report. Here also in column number 8, Your Lordship, the policy number is mentioned. It is the same number that is mentioned as the certificate number in the policy document.
Yes.
Now, Your Lordship may kindly come to page number 62, Exhibit A. 60 and 62. This is the Exhibit A, the policy, Your Lordship. That was exhibited by the claimant.
Exhibited by?
By the claimant. This is the policy certificate. Certificate number 351007311 26200705817. Your Lordship, on the extreme right, there are two columns, Your Lordship, valid from N2. Valid from 20/06/2012. And it was valid up to midnight of 19/6/2013. And the accident occurred on 30/9/2013. As such, at the time of the incident, Your Lordship, the policy was not on force.
So now you come to Form 54, where it is stated that the policy is valid up to 19/6/2014.
It was
In
wrong.
column number 8, it has been mentioned.
Yes, Your Lordship, it is wrongly mentioned, Your Lordship, because the certificate number given in the AIR is the same number which has been exhibited as the policy document. And in there, Your Lordship, it is typed that the policy is valid up to 19/6/2013, Your Lordship. There is some manipulation in the AIR. Because
manipulation
in the AIR, Accident Information Report, because the certificate number mentioned in the AIR is the same that has been exhibited by the claimant as Exhibit A. And whereas in the Exhibit A, it is clearly written that
It is valid up to 19/6/2013, Your Lordship.
So after this date, 19/6/2013,
Lordship,
the policy was not renewed with your
not renewed.
company.
Because it is on the part of the insured, whether they will go to the same insurance company or they will go for the other insurance company, Your Lordship. Because once the policy is expired, Your Lordship, it is completely in the domain of the insured to which company he opts for, Your Lordship, for doing the insurance. And at the time of filing the claim petition also, Your Lordship, the policy number mentioned in the claim petition is the policy number mentioned in this policy, Your Lordship, which has got expired, Your Lordship.
Yes.
I am on behalf of respondent number one, Lordship.
Pardon?
Claimant, respondent number one, Lordship.
Hmm.
Lordship, accident was took place 2013, Lordship. Till date, Lordship, I am suffering, Lordship.
Pardon?
Suffering, Lordship. Till date, I am not receive any compensation, Lordship. So, Lordship, my humble
Accident
submission.
took place on
13/9/2013, Lordship.
13/9/2013. Now the question is whether the policy was valid on that day or not.
If policy is not valid, Lordship, direct Lordship, owner, Lordship may compensate. Vehicle owner, Lordship.
Notice was issued to the owner and they have appeared, Your Lordship, but today they are not here. Notice was up to them and the name is reflected in the cause list also, Your Lordship.
Today?
Today. Their name is reflected in the cause list for respondent number 2, the owner of the vehicle. Item number 11.
SP Chaudhary.
Item number 11, Your Lordship. Respondent number.
You know, Mr. A Dev,
Lordship,
respondent number 2 or respondent number 2. A Dev and Miss S Sharma.
I'm sorry, Lordship, their contact number is not available.
You go for respondent number 1.
One, Lordship.
You know Miss S Sharma?
No,
Or
Lordship.
respondent
S Hussain
number
on behalf of AT Sarkar. On behalf of AT Sarkar. S Hussain, my name is.
Pardon?
On behalf of AT Sarkar.
You are appearing
On behalf of AT Sarkar.
it is Sarkar.
Yes, Lord.
No, I am asking you about S Sharma.
No.
Miss S Sharma. So let us keep the matter as further then. Court master will try to contact the council because without hearing the other side, it would be improper to fasten their liability upon the. Huh? Heard, Mr.
H. Buragan, Lordship.
Yes. Yes. Okay. And also heard, Mr.
S Hussain on behalf of AT Sarkar.
S. Hussain, Learned Counsel appearing on behalf of Mr. It is Sarkar. Learned Counsel for the respondent number 1. None appears for the respondent number 2. Please the matter on. Sixth of May. 6th of May.
Obliging.
Further.
Obligation.
On last,
Are they interested to pursue the matter?
Lordship, earlier occasion Lordship has recorded. Thereafter, earlier although order also Lordship has reflected that without absence Lordship will decide the matter. Because the matter was not a complicated matter, is a very simple matter. Matter is relating to Lordship the agreement for sale. I have filed a suit for specific contract. There is a lacking of the statement, then I am ready and willing to perform my part of the contract. Only because of lacking of that part of the statement, suit filed by me was dismissed by the trial court. Appellate court allowed the appeal. Thereafter, the respondent has filed this appeal on the ground that there is no averments in the plain that ready and willingness to perform my part of the contract. That is the subtle question of law. And Supreme Court has already stated, full bench of the Supreme Court has already discussed this matter, and Supreme Court's full bench has categorically held that from the averments made in the plain, court have to see whether plaintiff is ready and willing to perform his part of the contract. If that averments is available from the reading of the plain, it's sufficient.
No, Mr. Goswami, in absence of the other side, we cannot decide the matter on merit. We have to dismiss
Lordship, in case of criminal matter, that is Lordship. In case of second appeal, it is a second appeal of Lordship 2016, now 2025. So 9 years old second appeal. If Lordship dismiss this case for default, it will create a problem again. We will file for execution. Lordship has already rejected vacated the stay order on earlier occasion. And if Lordship dismiss for default, we will have to file an application for execution. Then they will again come before this court for restoration. It will continue again 10 years. In case of a criminal matter, Lordship cannot dispose. But in case of civil matter, Lordship have to decide.
No, is there any authority on that point?
Lordship, there is the authority on this point because second appeal have to be disposed of.
You show me the authority then.
Then the Lordship may take this matter after some time. I will place the judgment. Law has been settled by the full bench.
No, that's all right. That point is. But regarding this,
Lordship, I will place the judgment.
Okay.
After some time.
May it please your Lordship. Itu dilakukan. Yes. Mata seperti itu hasilnya. This appeal preferred by one Ghanakanta Kotoki matter against the judgment dated 11/3/2019. Passed in.
so the suit was dismissed.
Suit dismissed, therefore appeal preferred under section 28 of the Hindu Marriage Act. So the husband, she claimed decree of divorce. And he claimed divorce on the ground of section 13, subsection 1, clause IA and IB. IA is related to plurality and IB is related to desertion. So these two issues are the core issue in the proceeding matter. And that is why, my lord, Barnet trial court below frames such issues. First issue is related to cause of action, whether there is a cause of action in the suit or not. And the learned court below, when framed the issues and determined that the issue number 1, that is annexure C, page 32. That is the impugned judgment, my lord. 32 is the impugned judgment which has been challenged by the appellant by before this honorable court. The issue that is reflected in the judgment at page.
So the trial court has issued on a frame only one issue, that on the point of desertion.
That issue, my lord. Only one issue.
And
It is
there's a
rejected,
cruelty-
desertion.
Upon cruelty, no issue was framed.
No frame. And not determined matter. But learned trial court below says that there is a cause of action.
There is?
Cause of action. Cause of action exists. My question is, what is meant by cause of action? It is a legal statutory proceeding filed. So establish his legal right. And facts and circumstances says that there is a cause of action on perusal of the pleading of the plaintiff. So your lordship rightly pointed out, only for one issue, it is dismissed. Desertion. Question is, my lord, in the year 2014, this couple.
So you first show me the plaint where you have taken that
Yes.
environment.
Yes, I am coming to that. Before I wanted to project one thing before your lordship as page 47, mind. Page 47, which are the issues framed by the learned court below.
Yes.
First, cause of action, whether there is any cause of action for the suit. That is decided in favor of the plaintiff. The first cause of action. That is the first issue decided in favor of the plaintiff. That is in favor of the husband. And cruelty issue has been decided also in favor of the husband. Now, last
No. Upon cruelty, no issue was framed.
issues framed, but determination has been wrongly done by the learned court below. Issues framed for 47, page 47.
Yes.
Issues frame, cruelty issues frame, whether the respondent
Okay,
after
okay.
so and so
Treated the
minutes
petitioner with cruelty, yes.
is
Okay.
cruelty. That is cruelty issue frame, but it is not in accordance. Our lives.
Coming item 12. Lordship, I have verified. There are contrary judgment of this court and Bihar High Courts, but Supreme Court has settled the matter now that Lordship can dismiss the matter for default, not on merit. Because Order 41 Rule 17 is also applicable in second appeal as per amendment of the CPC. So Lordship can order 41 Rule 17 has specifically stated Lordship can dismiss this case for default. And Supreme Court has categorically, it has been decided. Dismiss for default.
Okay. None appeals for the appellant on call.
Earlier non-appearance also. Earlier non-appearance also Lordship can record.
Yes. Above Mr. S.K. Goswami, Lord and Counsel for the respondent present. Order dated 25/3/2025 also indicates that on that day, the appellant, that day also the appellant remain absent. Or no, remain unrepresented. Therefore, on 25/3/2025 and also on 11/3/2025, the appellant remain absent, for which in order dated 25/3/2025, it has been observed that in the event of the interim this court was inclined to vacate the interim order passed in IS Civil number 291 of 2016. Since the appellant remained absent on 3 dates consecutively, this court is inclined to dismiss this appeal for non-prosecution.
I'm sorry, Lordship, I have given a wrong submission earlier. I'm sorry.
in view of order passing, appeal number so the I stands closed.
Item 16.
May it please your lordship.
Yes.
Lordship, there is an appeal under the Employees Compensation Act, and the substantial question of law which is involved is whether the employee can be construed to be covered under the insurance policy, which is admittedly a act only policy and not a comprehensive policy.
The substantial question of law was framed.
Well, it was framed, I think, as per order dated 5/1/2022.
5/1/2022.
The matter was admitted on that day.
No, whether that question was framed.
I think it was framed.
Have you gone through the record?
Your lordship, we have submitted a draft, but it should be there.
See the record. Exact.
Item 19.
Please, your lordship.
Mr. Goswami,
Yes, sir.
we have very limited time.
Yes.
Can we finish this matter before the court works over?
It will not be possible. It will not be possible.
Cannot be possible.
Because matter is very contentious. My submission is that a vehicle has been implanted. My vehicle was not involved in the accident. A GD says something and without any correction in the GD entry, maybe subsequent GD entry, the investigation starts with a different vehicle. Now, Lord Sabhi, it's a settled question of law. So GD entry is to be treated as a kind of a FIR. Now, how does one ignore a FIR if it is recorded there? There is a decision of the 5 judge bench of the Supreme Court is very significant. Lord Sabhi.
Yes, madam, you received the record.
Yes.
Acha. Okay.
Yes.
Whether that case was disposed of. Okay.
My lord, there, worship, may I submit on your worship? Whether the evidence introduced in the a criminal case can be relied in the MSCT case, lordship. There is a Supreme Court judgment, lordship, that the evidence introduced in the criminal case cannot be relied in the claim petition while deciding the claim petition. So, whether this would be necessary or not, that
No, there was observation of this court. Therefore, the record was called for.
yes, your lordship has directed on the last occasion. But to that effect, lordship, there is a Supreme Court lordship I have brought on. That evidence of the trial court cannot be relied in this case, lordship. Evidence of the criminal case.
No.
Yes,
The
it's just
record was not called
document.
for to rely upon the evidence of the trial court. It was called for to ascertain
Yes,
whether another vehicle is planted in place of the original vehicle.
My lord, absolutely, lordship, they have not, lordship, challenged the FIR as well as the charge sheet. They have not challenged.
No, they have raised the issue. Once the issue is raised before the court, we have to consider it. So, madam, you please open the file and go through it in terms of the order passed by this court in 19/9/2024. And we will list the matter on next Tuesday. After vacation.
Vacation will be good.
Okay, 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 okay. Heard Mr. Goswami, learned counsel for the appellant, and Mr. Khan, learned counsel for the respondent number one. Respondent number one. And Madam Burman for respondent number five. And Mr. Padgiri for respondent number 3.1 to 3.4. 3.4. Also one and two also. One and two also. Okay. Pursuant to order of this court 19/9/2024, Ms. Burman has produced the GR record and the general diary before this court. Due to scarcity of time, the matter stands adjourned for the day to be listed on
In the month of May. No. 13th May.
sorted.
First May.
1st of May. 1st of May. Pardon?
Yeah.
Okay, RSS will also reflect the name of GA Assam in the cause list.
16.
It's not there, Your Worship. But I have a draft copy of.
Whether you have pointed out the court that there is a requirement for framing of substantial question of law before admitting this appeal.
No, Lordship, I was not appearing that time. Maybe some
So
miscommunication.
have you gone through the substantial question of law?
There is no substantial question of law, my lord. I have received the copy, my lord. Actually, I am appearing for all the claimants, my lord. The wives, sons and daughters, my lord, were appearing, my lord. The case was.
You see, there is a requirement for framing of substantial question of law at the time of admitting the appeal.
At the time of appearing, I was not, I think.
No, maybe, since he has submitted the suggested substantial question of law, you please go through it. And on next date, we'll fix it and we'll record is called for.
My lord.
Record is there. Record is there.
Record is
Record
there.
is there, and today my humble submission is that since the case is pending and the claimants are seriously suffering financially, so I pray for disposal, my lord, because correctly decided. Tribunal
No,
correctly
no,
decided.
today it is not possible. We have to frame substantial question of law. That is the requirement of law that is provided in the act itself.
Then, my lord, any short date?
In the month of May only. First week of May. 8
My-
May.
After, if immediately after Bihu, my lord, may I
No,
pray?
Lordship, too many cases, hearing cases, so many cases already. Tuesdays and Thursdays are full.
So your matter may not
Matter will
reach
not
on
reach.
before after Bihu, immediately after Bihu vacation. In the
on May-
month of May, then
My lord,
first week of
on
May.
a convenient date, no.
Heard Mr. S. Dr. learned counsel for the appellant and Mr.
A. Ali.
A.
A. Ali.
A. Ali, learned
A.
counsel.
Ahmad Ali.
Ahmed Ali, learned counsel for the respondents. List the matter on
8 May.
8 May.
Obliged.
My lord, 8 May only date may be changed, my lord. I have some other.
On 13th May.
13.